From the list. The Lordship, it is underlined in final disposal, eviction matter, admitted appeal, Your Lordship. It was mentioned last week. It was listed in the supplementary list, Your Lordship, but it was not taken up. The execution case is listed on 23rd, Your Lordship. 23rd of
What is the year of the appeal?
2025, Your Lordship. Your Lordship had admitted it, Your Lordship.
Other side of that yet?
Yes, Your Lordship.
You can see, I'm not sure. What?
From supplementary list, Founders item 1, second appeal 51 of 2025.
Is it for withdrawal? You are at appeal?
I'm for this comment, Your Lordship.
Item 1.
You want to withdraw? Essay number 1. I number 13010 of page 25 has been filed by the applicant with a prayer to withdraw the second. Consequent, the respondent has no objection to the prayer. Accordingly, the second appeal is dismissed. Pending I
From date list, this case item 4, second appeal 241 of 2018.
judgments referred to walking color photo.
Before my learned friend starts, I'm only my submission, Your Lordship, will recollect that I had said that my name was there recorded in 1971 as a person who was in illegal possession, and therefore if the state was claiming any, it was required to have filed a suit within a period of 30 years. So I had, during submission, Your Lordship took note of my submission that it was under Article 65. So Article 65 read with Your Lordship 112 of Article 112. Because Article 65 says that if any person files a suit based on title, then he has to file a suit within 12 years from the date when the possession of the defendant becomes adverse. So only 12 years have been provided there. But 112 says that any suit by or on behalf of the central government or any state government, including so and so, 30 years, when the period of limitation would begin to run under this Act against a like suit by a private person. So, whatever period of limitation is there for a private person, that would be extended to a period of 30 years for any suit by the state. That is my submission. So, Article 65 read with 112. This is one. And therefore, once my name was reported as a person who was in illegal possession in 1971, the state was mandatorily required to have filed a suit for based on title for recovery of possession till 2001. It did not take, therefore, this is all.
Essay number 241 2018. The arguments of the Appellant has been recorded in order dated 15/9/2025. However, when the case is taken up today, we have submitted that the period of limitation for the state to file any suit for recovery of possession would be 30 years, and therefore, and has referred to Article 112 of the Limitation Act. He submits that Article 65 and 112 are to be read together. In the previous order, there was no reference of Article 112 of the Limitation Act. That's it.
This is.
Blame, Mr. Blame the case. Yes, please.
The extent second appeal is against the concurrent, first and foremost, against the concurrent finding of fact by both courts.
What are those concurrent findings?
That I will say. The suit, the plaintiff is in the second appeal, and the suit brought by the plaintiff is for declaration of right title interest as well as for a decree declaring that settlement entry. Plaintiff has brought this suit for this relief, that declaring that settlement entry in respect of scheduled land of the plaintiff in records of right finally published on 10/8/1979, showing the khata in the name of one Vibhag, Bihar Sarkar, is wrong and erroneous. And for permanent injunction, restraining the defendants from interfering with the peaceful possession of the plaintiff over the scheduled land in any manner whatsoever, and also from taking forceful possession of the same or any part thereof. This is the relief that has been sought by the plaintiff. And the case of the plaintiffs, as set out in the plaint, is based on one sale deed exhibit 1, that is the sale deed dated 8/8/1956, that is purported to be executed in favor of mother of the plaintiff, late Masih Hani Tirki, from one Ladura. This is the only document upon which the plaintiff is basing his claim for tax, exhibit 1. And further claim of the plaintiff simultaneously is for acquiring title on the basis of adverse possession. In one hand, seeking declaration of title on the basis of one sale deed purported to be executed in the year 1956, and subsequently on the basis acquisition of title on the basis of adverse possession, both simultaneously, without disclosing the prerequisites and pleadings of adverse possession. And admitted position is that the record of right finally published on 10/8/1979 in the name of Anabad Bihar Sarkar, and illegal possession recorded of the plaintiffs. And further case, as set out by the plaintiff, is that regarding reference of one proceeding under section 83 CNT Act, and thereafter the reference is of the in the pleading is regarding notice under section 80 CPC, and in the notice it has been stated the notice dated 12/7/2005 for the settlement of the suit with the plaintiff, but the refuse for this. This and this I am referring this same from the judgment of the trial court that the plaintiff had sent the notice for settlement of the suit in their name, but they refused the same. This has been recorded in the judgment of the trial court page, running page of the brief, page number 26. That I am referring. And
Who refused it? The state.
the state regarding the reference of the state, because the plaintiff has stated here, it has been recorded.
Page number?
Page number 26, running page brief. Internal page 3 of the judgment. If your ladyship permit me, I may place. It is further stated the plaintiff has sent notice under section 80 CPC upon defendants on 3/5/2005 and thereafter on 12/7/2025 for settlement of the suit. For what? For settlement for the suit land with the plaintiff, but they refused the same. So this necessitated the plaintiff to institute the suit.
These are exhibit number?
Exhibit, your ladies, exhibit is the 2/A. 2 and 2/A both two notices.
When was the suit filed? When was the suit filed?
Suit. So suit is of the year 2006.
Date 2006 का है ना suit?
हाँ?
ये notices दोनों पहले की
हाँ दोनों पहले हैं.
ठीक है? They also say in the notice that they are going to file the suit for the proposed relief.
Proposed relief.
Yes.
But the proposed relief for settlement of the suit.
No.
This has been
अरे
covered.
एक पहले पेज तो पलट के देखिए.
The trial court has
अबे
recorded.
आप trial court has recorded, we will not see the document.
अरे
जिसका कोई substantial question of law नहीं है, आप उसके बारे में बहस कर रहे हैं.
your
ठीक
ladyship
है?
will
And we will not see the document.
your ladyship can certainly can see.
Have you seen the document?
But this is the
Have
pleading.
you seen the document?
I have not seen the document.
Then have a look at it.
But the
Please do not argue anything which is beyond the frame of substantial question of law.
I am not beyond them. But this has been incurred.
Do you want to say that this is not beyond the frame of substantial question of law? Which substantial question of law covers this point of section 80 of the CPC?
I am submitting because of the fact.
No,
If Lordship,
please do not submit
हम
because
ठीक है
of any fact.
substantial question of law के beyond नहीं जाएंगे, लेकिन substantial question of law emerge from the pleadings of the parties certainly. So pleading that has been incorporated by the trial court judgment.
Pleading is the finding.
Pleading not the finding.
Then-
Pleading not a substitute of proof.
Please don't shout at the top of your voice, okay? I must tell you one thing. We are supposed to confine ourselves to the substantial question of law. Whatever submission you are making, show me it is referable. No, show me it is referable to which substantial question of
I
law.
am coming on this. I am showing just your ladyship. Why your ladyship?
No, we don't want to see all this.
What?
The points which have already been settled by both the courts, that section 80 CPC notice was given, and that is not the substantial question of law. We will not hear anything on this point.
ठीक है
And otherwise also you have not seen the document and therefore you are making this submission.
ठीक है लेकिन जैसा लिखा हुआ है हम उसी को पढ़ रहे हैं हम बाहर इसके बियॉन्ड नहीं पढ़ रहे
जब
हैं
सेकेंड अपील एडमिट हो जाता है ना तो सारा सबमिशंस रिकॉर्ड देख के किया जाता है. रिकॉर्ड किस लिए आता है?
ठीक है
तो आपने तो नहीं देखा रिकॉर्ड.
ठीक है जो जजमेंट में है उसको हम पढ़ रहे हैं
जजमेंट में फाइंडिंग है कि सेक्शन 80 CPC
नहीं
का proper notice है.
लेकिन उन्होंने जो इनकॉर्पोरेट किया है
बहुत अच्छी बात.
वो जो
Please don't argue on such points.
अच्छा ठीक है उस बात नहीं जा
You confine yourself to the substantial question of
आप सबसे क्वेश्चन ऑफ लॉ पर ही
You confine yourself to the substantial.
सबसे क्वेश्चन ऑफ लॉ पर ही
Yes,
है
yes.
the defendant appeared and opposed the suit. हम तो हमारे गला और हम तबीयत नर्म है मेरे हम आई एम सफरिंग फ्रॉम फीवर स्टिल ऑन माय रिक्वेस्ट इट हैज
बहुत बड़ा हमारे ऊपर उपकार
नहीं नहीं
करना है।
हमको नहीं हम दिस इज माय ड्यूटी दिस इज माय ड्यूटी दिस इज माय ड्यूटी
आपके कहने से आज रखा
हां इसलिए तो हम आ गए नहीं तो
बहुत
अगर
अच्छा।
अगर हमने इनको भी इंटीमेट किया कि हमारी तबीयत खराब on the contrary the defendant appeared and opposed the suit besides taking the plea legal plea of the suit being barred by limitation and section 80 CPC. This pleading is there, and the provisions of CNT Act, BR Act, and Specific Relief Act, and further pleading is that the plaintiff has not justified his physical possession on the suit land since 8/8/1956. The land was under the ex-landlord Raja Jagdish Chandra Dhawal Deo, and after Jamindari abolition, the entire land of ex-landlord under the BR Act 1950 is vested to the state of Bihar, now to the state of Jharkhand, and the state government becomes paramount owner of the land with the intermediate interest. The state government has got all right title interest on the suit land. After vesting the land of its landlord, there was Khanapuri and record of rights in respect of the plot land and houses having prepared a record and registered to which is kept in Ancel office as the record of right, and the record of right in the name of plaintiff do not find place in the entire claim of plaintiff wrong. Further submitted that the suit land is vested under the possession of the state government since 1956, and there was survey settlement in the year 1964 when the entire suit land is recorded in the name of the state of Bihar, now Jharkhand. There was final survey and settlement in the year 1979 when also the entire land is vested to the state of Bihar and recorded in the name of the state of Jharkhand. The plaintiff should have filed the title suit within the limitation period. I am reading from paragraph number 3 of the trial court judgment. The plaintiff should have filed his title suit within the limitation period, but filed the title suit after lapse of limitation. So the suit is not maintainable and the suit cannot proceed. The plaintiff should have moved the deputy commissioner for correction of his name. This is regarding the provisions. He was in possession of the land on vesting, but he did not move the deputy commissioner for correction of the state wrong record. He should have moved to the CO, LRDC, ADC, and DC for settlement of the state plot of land if he was in possession and there was any wrong recording in the service settlement, but he did not do so. He should have moved the DC for mutation of the said land in his name, but he did not do so. He should have moved to the circuit officer for fixation of rent for the suit land if he was in possession of the land, but he did not do so. This falsified the entire claim of the plaintiff that she is in actual possession and physical possession of the land since 1956. She should have filed the petition under section 83, 86, 89, and 96 of the CNT Act for correction of her claim to justify her petition, but she did not do, and therefore the entire claim is wrong. The adverse possession of the plaintiff, the legal possession is like in Gochar, and she is liable to be dictated under the process law. The land recorded in the name of Forest Department, Government of India has got all right, title, interest, and question and threatening, but by the staff of Forest Department is not correct. The claim of plaintiff has raised only to justify the delay in filing suit. The land is itself recorded in the name of state government and Forest Department, so the question of threatening does not arise. That is further submitted, the plaintiff himself had admitted the suit property is recorded in the name of Bihar Sarkar. And the same is also shown in remarks from illegal possession of Masid Hani Tirki, wife of Joseph Tirki since 1971. This illegal possession cannot give right to possession of the plaintiff, and the plaintiff is liable to be evicted from the suit land under the process of law. The claim of plaintiff regarding possession of the suit land is wrong. Further submitted, the cause of action for the suit arose from the date of vesting in the state of Bihar, as well as from the service settlement 1964, as well as final service settlement 1970. Hence, the plaintiff has got right title, no right title or interest on the government land. That is afraid that suit is liable to be dismissed. Altogether, 5 issues have been framed. The issue number 4 and 5 that has been dealt by the learned trial court in para number 6 of the trial court.
How many witnesses did you examine? How many witnesses did you examine?
On my behalf, no.
Any document produced?
No. Defendant has not produced any document.
So in your written statement, whatever you have stated, you have not produced any witness in support of that
Yes.
submissions
Yes.
made in the written statement.
But the findings recorded, the trial court has dealt the issue of
I want to know from you, what was your stand with respect to the registered sale deed of the year 1956?
Both the courts concurrently held the same to hit under Section 46 of the CNT Act.
Nothing else?
Both the courts.
Did you take a plea that the sale deed is hit by Section 46 of the Judicial
Pleading is that the suit is barred under Section 46 under provision of CNT Act. Pleading
What
is
does
there.
that mean under provision of CNT Act?
Provision since the suit is barred under the provision of CNT Act, that
How
is pleading.
the suit is barred under provision? Did you say that this sale deed is illegal, void ab initio, or otherwise not enforceable in law? Because this sale deed suit is barred under Section 46. Is the sale deed barred under Section 46? And if you rely on this, and if you say that the sale deed is barred under Section 46, will you become the owner of the property?
Suit is of the plaintiff. Plaintiff has to stand on his own. Plaintiff cannot
No,
succeed.
therefore,
Cannot succeed on the
it
mild
is absolutely two different things. That the suit is barred under Section 46 and the sale deed is hit by Section 46. Both are two different things altogether. Sale deed is of the year 1956. Suit is barred under Section 46, yes. Substantiate. How the suit is barred under Section 46?
Finish. The pleading that has been taken that the suit is barred by limitation and under the provision of CNT Act. CNT Act means provision of CNT Act, but meaning thereby that the sale deed is itself. Sale deed does not confer does not confer title to the plaintiff.
How do we read into this sentence that
Because
suit is barred when is the suit barred under Section 46?
Because
When is the suit barred under Section 46?
since without permission of the litigant.
No, that is the sale deed is barred.
Sale deed, that is sale
No,
deed.
suit being barred is nothing.
But the basis of the claim of the plaintiff is rests on the basis of sale deed.
That is not your case, mister. Please appreciate this. That is
What
not your
your
case.
ladyship
It is not your case
raising.
that the sale deed is hit by Section 46 and therefore you have not even stated that it is null and void. You have not even stated that the transfer of property by virtue of the registered sale deed is hit because of any provision of law. That is not your case. That is not your case. दोनों अलग बात है. Sale deed is barred under Section 46 is different from suit is barred under Section 46.
But your ladyship has posed the query. But one thing, whether the point of law can be resolved when the sale deed is itself barred, whether I will not be allowed to raise this point or not.
No, you will not be because it needs foundational pleadings.
Question of law always
It
not.
is not a pure question of law.
Question of law always not
It
necessary.
is not a pure question of law. It needs foundational pleading. It has to be the responded to by the plaintiff.
And both the courts, finding of fact by both the courts that sale deed is hit by Section.
That is what I am saying. There is no evidence from your end. The court is absolutely with the state, but this court will not be with the state. You are at par with the.
No, court is not.
No,
This is
yes. In a case, just imagine, in a case where the state does not even need evidence, oral or document, right? The state does not say that this particular sale deed is hit by, is otherwise void, illegal, or there is no prior permission of the deputy commissioner pursuant to this sale deed. You are absolutely silent on that. But still the court goes on to say that it is hit by Section 46. And if it is hit by Section 46, has the court declared the sale deed null and void? Has the court declared the sale deed null and void? Is there any declaration that the sale deed is null and void because of no permission under Section 46?
So since there is no counter claim of the defendant state, now the defendant has filed the suit, separate suit, but the plaintiff has brought the suit on the basis of sale deed. On the basis of sale deed.
We take care of it.
Plaintiff is seeking.
You see, I am asking this question because I want a response from you.
Your ladyship may pose query. I am not. But the suit has been brought by the plaintiff on the basis of the safety, and on the basis and simultaneously on the basis of adverse possession, both. Para 9, wife and I always come with fair hands. I never come with any hide and seek.
You read what is your pleading in the plea?
I am reading
In the written statement.
Yes. I am reading from start. That this is suit. May I read from start? That this is suit for declaration and permanent injunction with respect to the land measuring area so and so is not maintained either on point of law or on the facts of relief claim. Second, that the suit is barred by limitation. The suit is barred by section 80 CPC and semi liable to negative. Suit is barred by CNT Act as well as under the VLR Act. The suit is barred by the specific relief act. Whoever is total indices, the suit is undervalued and is not less than 5 lakhs. Unless the involvement fee is paid by the plaintiff, the suit is not maintainable. The answering defendant number 1 denies and disputes all the arguments made in the plaintiff, save and except what are specifically admitted. The statements of the plaintiff in para number 1 is no comment as it is matter of record. The statements of the plaintiff in para 2 is wrong. The plaintiff has not justified his physical position of the suit land since 1956. The land was under this landlord rather than this was there. And the Jamindari evolution, the entire land of this landlord, the entire land of this landlord is vested to the state of Bihar. Now the state is Jharkhand and the state government to the paramount owner of the land with intermediary interest. The state government has got all rights, title, interest on the suit land. After vesting the land of this landlord, there was Khana Puri and record of rights in respect to each plot of land and houses has been prepared and recorded in the register 2 is kept in the Anchal office as a record of right. In the record of right, the name of the plaintiff do not find the entire claim of the plaintiff wrong. The entire land is vested under the position of the state government since 1956 and there was survey settlement in the year 1964 when the entire suit line is recorded in the new state of Bihar. And there was the final survey settlement in the year 1977 also the entire land is vested to the state of Bihar and recorded in the name of state of Jharkhand. The plaintiff should have filed suit title suit within limitation period and filing this title suit after lapse of limitation period. The suit material suit cannot proceed. The plaintiff should have moved to the Deputy Commissioner for correction of the name if he was in possession land on the vesting and recorded in the name of the state of Bihar, now Jharkhand, but he did not move to the Deputy Commissioner for correction of the said wrong record. He should have moved to the CO, LRDC or ADC or DC for settlement of the said plot of land in his name if he was in possession and there was any wrong recording in the name of in the service settlement, but he did not do so. He should have moved to the Deputy Commissioner for DC for mutation of the said land in his name, but he did not do so. If he should have moved to the circuit officer for fixation land for the suit land, if he was in possession, but he did not do so, falsified the entire claim that he is in equal possession and physical possession of the land since 1956 is wrong. He should have filed a petition under section 83, 86, 89, and 96 CNT Act for correction of his claim in justify his possession, but he did not do so. His entire claim is wrong. The statement plaintiff in para number 3 is wrong. The statement of plaintiff para 4 limited that the entire that he acquired the individual right and interest and this first person is your person is like brochure and is liable to be dictated under the process of law. That the statement of the plaintiff in para 5 is wrong. It is wrong to say that the staff forest when threatened the plaintiff would dissuade from suit land, but on the basis of wrong and erroneous entry in the record right. Finally published on 10th August 1979. That the statement is wrong. The land is recorded in the name of Forest Department and Government of India has got all rights in interest and the question of threatening by the plaintiff of Forest Department is not correct. This claim of plaintiff is only to justify the delay in filing suit. The land is itself recorded in the name of the state government and Forest Department. The question of threatening does not lie. The defendant, the department will file eviction suit immediately and the question of threatening does not lie. The statement of the plaintiff in para 6 is wrong. The statement of the plaintiff in para 7, the plaintiff has himself admitted the suit, but he is recording the name of Bihar Sarkar. The same is also shown in the remarks of the legal position of Munsif Hani. wife of Joseph the Peace 1970. The legal position cannot give right to the possession to the plaintiff, and plaintiff is liable to dictate the suit line under the process law. The claim of plaintiff regarding the possession of the suit line is wrong. The statement of the plaintiff in para 8 is wrong. The statement of the plaintiff in para 9 is wrong. The suit line is recorded in the name of the state of forest, state of forest. The statement of the plaintiff para 2 is wrong to say that eviction on the suit will be possible from property is wrong. The land is recorded under the state of Bihar and forest order and is bound to be evicted under the process law. The statement in para 11 is wrong. No proper notice under section 80 CPC has been served to the Deputy Commissioner. The statement of plaintiff para 12 is wrong. The plaintiff has got no manner of right at interest to the government land. The statement of para 13 is wrong. The statement of plaintiff para 14 is wrong. The action for the suit arose from the date of testing in the state of Bihar as well as from the service settlement 1964 as well as final service settlement 1979. The statement of plaintiff para 15 is wrong. The suit property value actually 5 lakhs and unless and the following court prepares suit will not proceed. The statement of plaintiff para 16 is wrong.
You see, you said that the suit is barred under the provision of CNT Act.
No,
Just a moment. A barred statement has been made in para 4 and clarified in para 2. You say that it is barred under section 83, 86, 89 and 96.
that is.
Yes, you have made specific provision that it is barred under section 83, 86, 89
Regarding
and 96.
the same, that is incorporated.
Yes.
But the statement is also there that the
Show me one statement in your entire written statement that this particular sale deed is hit by section 46 and therefore it is null and void. Show me one statement. And from where do we assume that the vendor is a tribal? From where do we assume this? Is there any assumption in law?
No, there is no evidence.
Then, from where do we assume
There is
that?
no evidence.
Unless he is a tribal, right?
But
46 will not be attractive.
But in the deed, if it is mentioned the caste,
We do not know what is mentioned in the deed.
in the deed in the caste.
So, therefore, it can't be like this.
And the finding, listen, I am coming on the findings of the learned trial court regarding this.
अभी तक आप जितना बहस किए हैं तो लिखने दीजिए. Just a moment. Let me just put it in right.
हम सब्सटेंशियल क्वेश्चन लॉ पर आ रहे
हाँ रुक जाइए. जितना बहस किया उतना तो हमको ड्यूटी है ना लिखने का.
हैं ठीक
भूल ले जाए. भूल ना जाए.
नहीं कैसे हो गया
The learned counsel for the respondent state has submitted that there are concurrent findings recorded by both the courts. He has submitted that the suit was filed for declaration of title and also challenging the settlement entry of 1979, stating it to be wrong. The plaintiff claimed the property on the basis of sale deed exhibit 1 registered sale deed exhibit 1 dated 8/8/1956 in favor of the mother of the plaintiff and simultaneously claimed adverse possession without disclosing the foundational pleading which are required to be pleaded and established for claiming adverse possession. He submits that otherwise also the claim of the plaintiff on the basis of registered title deed and on the basis of adverse possession are simultaneous and conflicting to each other. The learned counsel has then submitted that a reference has been made to the proceeding under section 83 of CPC by the plaintiff. He has referred to the submissions as recorded by the learned trial court that notice under section 80 CPC was given primarily for settlement of land and not for filing of suit.
That is recorded in the trial court.
But the state had refused the settlement. He has further stated that the suit was not only a specific plea was taken, that suit was barred by section 80 CPC and also was barred by litigation. The learned counsel submits that the learned counsel has read the entire summary of the written statement from the judgment passed by the learned trial court. He has specifically submitted that a plea was raised before the learned trial court in the written statement, that the suit was barred by Chotanagpur Tenancy Act as well as under Bihar Land Reforms Act. And further, in paragraph 9, the various provision of section of the Chotanagpur Tenancy Act, namely section 83, 86, 89 and 96 has been referred to. He submits that since a plea was raised that the suit was barred by Chotanagpur Tenancy Act, therefore, the learned courts have rightly entered into the point that the registered sale deed, that no prior permission of the Deputy Commissioner was taken before entering into the registered sale deed of the year 1956. Right?
If you allow me to place the finding on issue number 4, that is relating to title of the issue number 4 relates to whether plaintiff has right, title, interest and possession and has perfected his title by advance possession, and 3 and 5 is whether plaintiff is entitled to get a degree as prayed for. The findings of the trial court has dealt the same in para number 6 of the impugned judgment. These issues are interlinked to each other, and so both are taken up together for the convenience. I am not reading entire by this issue. This court has to decide whether plaintiff has right, title, interest and possession of the suit, and also for the plaintiff has perfected his title by advance possession, and whether the plaintiff is entitled to get a degree as prayed. In this regard, PW1 Ruby Rai Devi, the plaintiff himself, who herself plaintiff in this case, the witness had fully repeated in the plaintiff in her examination. If she has stated that land measuring in area so and so, more described in her usual physical possession since long from 1856. Her mother, Masih Khanti, had purchased Deva from Ladura by virtue of sale deed number 351 dated 1856, and she along with her family started residing there by constructing a house thereby without any objection from India. She had further stated that after the death, her mother she inherited Deva property and continued in possession thereof without any objection from India. On the basis of the aforesaid act of possession, she acquired right, title, interest as well as possession thereof universally were within the knowledge of the concern. She has further stated she was in possession of property on 15,401 person belonging to the staff of the forest department. Threatened her to dispose from the suit property on the basis of wrong entry in the record of life finally published on 10/8/29, and for the first time she came to know that suit property had been wrongly recorded in the name One Vibhag, Bihar Sarkar. Thereafter she searched and inspected the record of rights in respect of the suit property and found that suit property is wrongly recorded in the name of One Bihar Sarkar. Remarks column is shown in the legal position of Masih Khanti. She has also stated that she is in legal position of the suit property since more than 48 years from the time of her mother. Since 1856, without any interference from any economy, she required indivisible right and interest by virtue of her position well within knowledge. Further, the defendant has filed a case under section 83 CNT with respect to suit plot bearing case number so and so, in which assistant settlement officer filed his order dated 24/8/1997 had confirmed her mother's and her possession of suit land. One Bihar Sarkar had no manner or possession of suit property at any point. Her name has been notated in the Mangu Mutihar area in respect of suit. In cross examination, for that I have read it. In cross examination, she had stated the suit property was purchased by her mother in the year 1992 from Ladura. In para 25, specifically it has been recorded. In para 25, she had stated the suit property has been recorded in the name of the state government in 1964 record of right. Again, suit land is recorded in the name of One Bihar Sarkar in the record of right 1976. She has also admitted the earlier suit land belongs to ex-landlord of West Bengal, namely Gobar Mukhi, but after Jamindari order, the said land was vested to the government of Bihar. This has been recorded. Referring para 25 of the cross-examination of the plaintiff herself. In para 28, she has said she could know whether her name was recorded in the register 2 with respect to suit line after Khana Pujana. In para 30, she has stated she knows above illegal presence. She never gave any application to CO or DC for realizing rent with respect to the suit. Thereafter, the statement of the deposition of other witnesses. The para 6.2 PW3 6.1 relates to
आधा नहीं पढ़ी
पूरा पढ़ा पूरा
6.1 मत
हम जो रिलेवेंट था इसको दिखाने के लिए
नहीं, जब आप पढ़ रहे हैं तो पूरा ही पढ़िए, नहीं तो आप सिर्फ relevant
नहीं ठीक है रिलेवेंट हम तो पूरे पढ़ रहे हैं
पूरा
PW2 Joseph Topo had stated he guaranteed the plaintiff in the owner and possession of the suit land. The mother of the plaintiff had purchased the suit land in the year 1956 and since then she along with her family started residing there by constructing house there without any reason from any government. After the death of her mother, plaintiff being her daughter inherited the said property and she continued in possession thereof. In cross-examination, this witness had stated in para 7 that he knows the plaintiff since 1951-52. He did not know the name of the father of the plaintiff. And para 8, he had stated that plaintiff had obtained the suit land by virtue of treaty. Said further, the suit land has been recorded in the name of government of Bihar Sarkar in the record of right of 1964 as well as 1917. This is also admitted. PW3, Ravi is said to be the son of the plaintiff. This witness is former witness who had proved some original punchmail receipt by Mango notified India Committee with respect to holding number 71, which has marked exhibit 26265 C. Hide order dated 4/7/2007. In cross examination, he stated he is the son of plaintiff. The suit land was purchased by his grandmother from Dadra in para 13. He has stated that her mother knew that suit land had been recorded in the name of government in service. This witness has stated that her mother knew that suit land had been recorded in the name of government in the service. Then her mother has filed a suit for correction of the entry in the record of right. In support of the case, the plaintiff has filed and exhibited some documents. Exhibit 7 is the certified copy of Khatiana Khata number 907, plot number 2988 and 2989 under ward number 9 notified area. On the result, it appears that Khata number plot number mentioned in the Khatian suit land of this figure. Khata number 907, plot number 2988 and 2989 is recorded in the name of Bihar Sarkar. Column number 7 of Khatian illegal possession of Masjid Khan has been shown since 1971. This Khatian is finally published on 31/8/1979. Exhibit 1 is the same deed dated 8/8/56, executed by one Ladula Ho in favor of the mother of the plaintiff. Same deed is in Bangla language. So the certified English version has been filed for perusal of the court. The Everland mentioned in the same related to the suit land is a mutual tract of both the parties. Exhibit 2 and 2/8 are the carbon copy of notices issued by the Litigation East Singapore and Secretary Department of Forest Government of Jharkhand, Ranchi under Section 83. Exhibit 3 and 3/A are the postal acknowledgement card in respect of Secretary Department of Forest State of Jharkhand. Exhibit 5 is certified copy order passed under in a case number so and so under Section 83 CNT Act passed by State Settlement Officer Singh. It appears the state has filed this objection case against the mother of the plaintiff with respect to suit land, which was ultimately dismissed. Exhibit 6/2/6/C are some consular receipt issued by Mango notified area committee in favor of the mother of the plaintiff related to holding number 71. Exhibit 8 certified copy of the village note of the mountain settlement Barahun District. Learned concept for the plaintiff has argued that mother of the plaintiff Masjid Khan had purchased this property from Ladura by virtue of registered sale deed number 3518 dated 8/8/56, and since then she along with her family started residing there by constructing house there without any interference or objection from any color. After the death of said Masjid Khan, the plaintiff being the daughter inherited the property and she continued the possession of her property without any objection from any color. Further submitted that in the meantime, on 5/5/1 staff of the forest department threatened the plaintiff to dissuade her from the suit property on the basis of wrong erroneous entry in the record of right, finally published on 10/8/1979, which cast a cloud in the mind of the plaintiff, and plaintiff for the first time came to learn that the suit property had wrongly recorded in the name of Bihar Sarkar. Further submitted the suit property in actual physical possession of the plaintiff since long more than 48 years from the time of her mother, since 8/8/56, without any interference from any government, and the plaintiff has acquired her individual right as interest then by virtue of her position, well within the knowledge of all concerned. Further submitted that with respect to the suit land against Masjid Khan, mother of the present plaintiff, the defendant filed a case under Section 83 CNT Act, filed case number 2268 of 72/73, in which Assistant Settlement Officer has confirmed the possession of the plaintiff and plaintiff mother, filed order dated 24/8/73. word from the name of the plaintiff has been mutated under the Malgo Notified Area Committee, and plaintiff used to pay holding tax to the Notified Area Committee, which also goes to. So the plaintiff has been coming in possession of the suit land since now. On the other hand, Wan Vibhag Bihar Sarkar has or had no manner of possession of her suit land or any portion thereof at any point of. So the plaintiff is entitled to get her right at interest of the suit property on the basis of sale deed exhibit 1, as well as on the basis of law of adverse possession. Also, learned counsel relied upon the following case law in subordinate. On the other hand, learned GP has argued the suit of the plaintiff is not maintainable either on point of law or the point or on the facts. Suit is barred by limitation, CNT Act as well as the Act and specific relief act. Further argued the suit is vested to the state of Bihar under BR Act, and now the state of Jharkhand is the paramount owner of the suit land, and the state got right at interest in suit land. Further submitted the record of right has been prepared after Khanapuri, and the plaintiff's name has not been appeared in the record of right. As such, the claim of plaintiff of the suit land is wrong. In the RS operation, the suit land has been recorded in the name of state in the year 79. The plaintiff should have approached to CO, LRDC, DC, or DC for settlement of land. If the plaintiff was in peaceful possession of suit land, if not, then he should file the suit within the period of limitation. The plaintiff should have filed a petition under section 83, 86, 89, 90 of the CNT Act for correction of wrong entry in the record of right. Further submitted the adverse position of plaintiff of the suit land is not sustainable. Whether the plaintiff is an encroacher are liable to be evicted from the suit premises under the process of law. The illegal possession of the plaintiff cannot give him right to possession. The story of forest staff created by plaintiff only to justify the delay in filing suit. The plaintiff should have filed the suit within 12 years from the date of final publication of the record of right, because the plaintiff has knowledge of a wrong entry in the year 73. He further submitted the entire land under Mauja Amanko has been vested in the state of Bihar in the year 56, and vendor of the said, namely Lalua, had no right to sell the landed property without any permission from competent, and as such the police of the suit land is encroacher, and so the plaintiff is not entitled to any relief claimed in the land. After hearing the argument of both the parties, after going through the entire pleadings of the parties, after analyzing the entire oral and documentary evidence adduced on behalf of the plaintiff, I find that it is a admitted fact that in the case the suit land, which is Khata number 907, plot number 298, area 0.040 hectare, and plot number 298, area 0.30 of Jamshedpur, recorded in the record of right published on 1970 in the name of Wan Vibhag Bihar Sarkar, and the mother of plaintiff has been shown as illegal possession since 1971. Identity of suit is also admitted fact. A suit is the exclusive case of the plaintiff. The mother of plaintiff, Masin Hani, had purchased the suit body from Ladra Ho, son of Hado Ho, Mangu, Jamshedpur district, by virtue of registered deed number 3518 dated 6/8/56. And since then, mother of the plaintiff and her family started residing by constructing house without any objection from interference or objection from the corner. After the death of her mother, plaintiff being the daughter inherited the suit body and has been coming in peaceful possession over the same without any obstruction from any corner. It is further case of the plaintiff. While she was in peaceful possession of the suit body, on 15 charges of one person claiming to be staff of the forest department threatened her to dispose her from the suit body on the basis of wrong and erroneous entry in the record of right finally published on 10/8/79. That the plaintiff searched and inspected the record of rights and inspected the suit property could know the suit property is wrongly recorded in the name of Wan Vibhag Bihar Sarkar, and her mother has been shown in legal possession since 1971 in Jharkhand. I find the plaintiff has nowhere mentioned either in her plaint or in her evidence on which date she searched and inspected the record of rights in respect of the suit property in the office of record room regarding the wrong entry in the name of Wan Vibhag Bihar Sarkar in the record of rights. I further find that in view of the aforesaid fact, plaintiff is claiming her right title of her suit property on the basis of sale on period of recital. It appears that under Laduraho has acquired land from the landlord on the basis of oral settlement, but Ender has not disclosed the name of each landlord in the aforesaid sale deed. Furthermore, the plaintiff has also not mentioned this fact in her pleading, nor has reduced any oral or documentary evidence on it. It further appears that Laduraho belongs to civil tribe and Fendi, mother of the plaintiff, belongs to Christian community. There is nowhere mentioned in the recital of the sale deed that Fender Laduraho has sold the suit land after taking permission from Deputy Commissioner. The plaintiff has not mentioned the fact in her plaint and has also not reduced any evidence on it. There is not any documentary evidence which could establish that suit land was sold in favor of mother of plaintiff after taking permission from DC section 46 of CNT Act described restriction on transfer of their right by Rayar. Section 40 CNT reads as follows: no transfer by Rayar of his right in holding or this is right or holding on any portion thereof by mortgage or lease for any period expressed or implied which exceeds or might in possible event exceed 5 years by sale, gift or any other contract or agreement shall be valid to an extent, provided that Rayat may enter into bandha mortgage of his holding or any portion portion thereof for a period not exceeding 7 years, or if the mortgage is a society registered or deemed to be registered under the Bihar Society Act for any period not exceeding 50 years. Provided further that an occupancy year with member of civil tribe may transfer with previous income to his right in holding or in person in holding by sale, exchange, gift, will to another person who is member of scheduled tribe and who is resident in the local limits of the area of the police station within which the holding is situated. An occupancy rate with member of the civil caste, backward or backward classes may transfer the previous sanction of the district concern his right in holding or a portion of his holding by sale, exchange, gift, will or lease to another person who is member of the scheduled caste of or either case may be backward classes who is resident within the local limits of the district within which the holding is clear. Thus, it is clear that vendor Lugra, however, had not sold the land in favor of the mother of the plaintiff after taking prior permission of the deputy consular, and as land has been sold without previous sanction by deputy consular, so sale deed executed by Lugra in favor of mother of the plaintiff becomes hard every so, and title cannot be passed to the mother of the plaintiff, though through so-called sale deed exhibit 1, both the plaintiff has not filed any sheet of paper regarding the suit land which could establish the peaceful possession of plaintiff over the suit land. I find neither malversary receipt with respect to the vendor nor any government rent receipt, mutation slip belonging to the plaintiff with respect to the suit land has been filed by the plaintiff. On the other hand, plaintiff herself admitted in her cross examination in para 25 that suit property has been recorded in the name of the state government in the record of right of 1964. Further stated that against suit land is recorded in the name of Bihar Sarkar in the record of rights of 1977. Plaintiff could have made an application to CODC for realizing the rent with respect to suit, but I find that plaintiff did not do so. Rather, she had admitted in para 30 that she never gave application to CO or DC for realizing rent with respect to suit. It 5 is the order passed in objection case number 2268 of 7273, which is going to show that the state of Bihar had filed an objection case against the mother of the plaintiff under section 83 CNT, in which the claim of the fruit state was ultimately received. But it is not clear from the order that what was the claim of the state and what order was passed in favor of the plaintiff. Although plaintiff had stated in para 9 of the claim that in the state case, assistant settlement officer had confirmed the position of the plaintiff with respect to, but on perusal of Unit 5, I find that it did not clear the position of the plaintiff with respect to the suit land has been confirmed. On the other hand, the court finds that in RS operation, the suit land has been recorded in the name of one Bihar Sarkar in the year 1979. And so, one Bihar Sarkar becomes the paramount owner of suit land. It is settled principle of law that entries in the record route shall be presumed to be correct unless proved to be incorrect. The plaintiff has failed to bring any substantive materials on record to rebut the aforesaid legal presumption. Furthermore, subsection 2 of section 2 of 84 CNT Act clearly says that the state government may by notification declare with regard to any specified area that record of right has been finally published or every village included in that area, and such notification shall be conclusive evidence of such publication. If plaintiff had any objection regarding the wrong entry in the record of right published in 1979, she should have filed a petition under section 83, 86, 89, 90 of the CNT Act for correction of a wrong entry in the record of right. But plaintiff did not do so. In this case, Exhibit 626 by C are some holding receipt issued from notified area committee with respect to holding number 71, which is going to show that these rent receipt bears the name of the developer. But in my view, mere essence of rent receipt by notified area committee do not confer any title to the plaintiff with respect to suit property. Thus, in view of the above discussion, I find that plaintiff cannot claim the right title of her suit land basis of slavery. Further case of the plaintiff and her mother came in possession of the suit land basis of slavery since 1856, that is, since long more than 48 years, without any interference from any corner. Thereby, the plaintiff has acquired her indivisible right title interest thereon by virtue of the first position, well within knowledge of all concerned. In the present case, I find that plaintiff is claiming her right title interest of the suit property on the basis of sale deed and also on the basis of law of first position. It is settled principle of law that one cannot claim right title over any land on the basis of sale deed as well as on the basis of law of first position simultaneously, because these two means are contrary to each other. In the present case, plaintiff is claiming a right title interest on the basis of sale deed Exhibit 1. So the law of adverse possession is not sustainable in the eye of law. However, it has been held in the Karnataka Board of Works versus Government of India reported in 2004 10 SCC 779 that plea of adverse possession is a pure question of law but blended on a fact law. Therefore, the person who claims adverse possession should show on what date he came into possession and what was the nature of his possession, whether the factor of possession was known to the other party, how long his possession had continued, his possession was open or undisturbed. It is further observed that a person pleading adverse possession has no equity in his favor since he is trying to defeat the right of the true owner. It is for him to clearly plead and establish all facts necessary to establish his adverse possession. In the eye of law, the owner would be deemed to be in possession of property so long as there is no instruction and non-use of property by the owner even of a long time would not be affect his title. In the instant case, it is reasoned that the mother of plaintiff has purchased the suit land by virtue of serial number 3518 dated 8156 and started residing by constructing house ground without any interruption from any corner. As such, since more than 48 years, plaintiff has acquired her indefeasing right, title, and interest done by virtue of her. On the other hand, I find that plaintiff has also pleaded the defendant has filed an objection case having case number 2298 of 7273 under Section 93 CNT Act with respect to suit. The existence of the aforesaid case goes to show that plaintiff cannot claim the continuance of her possession of her suit land without any interruption. Moreover, there is no documentary evidence on record to show that plaintiff or her mother has come into the possession of her suit land in the year 1956, or what was the nature of possession. It has also been held in by the Honorable Supreme Court in the case of Mandal Revenue Officer versus Gondola, Minkaya, and other reported in the year 2010, Supreme Court 744, that payment of land revenue by person making application by them to the government for assignment of the scheduled land or regularization of the possession completely demonstrates their case that the possession was open and hostile and they have acquired title by adverse possession. Honorable Supreme Court has held in SM Karim versus Judicial Sakina, the year 1964, Supreme Court 1254, that adverse possession must be adequate in continuity, in publicity, and extent, and a plea is required at least to show that. So, when possession becomes adverse, so the starting point of limitation against the party affected can be found. There is no evidence here when possession became adverse. If at all, did and mere suggestion in the relief clause that there was uninterrupted possession for several 12 years, or that the plaintiff have acquired absolute title was not enough to reach such a plea. Long possession is not necessarily adverse possession. It has also been declared in case on Rule Supreme Court reported in 1985 6 S309. If the appellant intends to plead adverse possession as against the state, he must claim his title and plead his hostile claim to the knowledge of the state that the state had not taken any action thereon within the prescribed period. Thereby, the appellant's possession would become adverse. No such stand was taken, nor evidence has been used in this behalf. Plaintiff has also not clearly said anywhere that the state government is the true owner of the suit land. Plaintiff had not accepted in her plan that the state government is the actual owner of the suit land. Therefore, in the absence of the crucial pleading which constitute the adverse possession, the plaintiff cannot claim that she had perfected her title by adverse possession against the state government. It has been held by the Honorable Supreme Court in the case of State of Rajasthan Harpul Singh, reported in 2005 SCC 652. So far, the question of perfection of title by adverse possession, and that too in respect of public property concern, the question requires to be considered more seriously and effectively for the reason that it ultimately involves the destruction of right title of the state to involve property and conferring upon a third party encroacher title where he had none. Honorable Supreme Court has held in para 34 of the case law reported in 2008 for JCR 71 Supreme Court that before party in this case, we deem it appropriate to observe that the law of adverse possession which ousts an owner on the basis of inaction within limitation is irrational, illogical, and wholly disproportionate. The law as it exists is extremely harsh for the true owner and the windfall for a dishonest person who has illegally taken possession of the property of the true owner. The law ought not to benefit the person who is a clandestine manner takes possession of the property of the owner in contravention of the law. This in substance would mean that law gives seal and of approval to the illegal action or activities of the land trespasser or who had wrongfully taken possession of the property of the true owner. It appears from the document Exhibit 7 that clearly the suit land belongs to one Vibhag Bihar Sarkar. Hence, it cannot be said that possession of the plaintiff was a hostile possession of the knowledge of true owner. It also cannot be said that possession of the plaintiff was open undisturbed. The possession of the plaintiff was also not hostile and continued over the statutory period. Plaintiff has also not even disclosed the date when their position becomes adverse position within the knowledge of the state. Hence, on the basis of discussion above, plaintiff has failed to fulfill the basic ingredients as required to establish their title on the basis of law of adverse position. I have gone through the entire rulings filed on behalf of the plaintiff, but it appears that the facts and circumstances of the case rulings are different from the facts and circumstances of the state case. Hence, on the basis of discussion made above, the court comes to the conclusion that plaintiff has not acquired any right title interest or suit land on the basis of self disputed in favor of mother of the plaintiff D1 as well as on the basis of first position. As such, the plaintiff is not entitled to a decree for declaration that the plaintiff has got every right title interest and position over the suit land and also not entitled to get a decree of relief as trade independent. According issue number 4 and 5 are deciding on the plaintiff. Issue number 3, by this issue, the court had to decide whether the suit of the plaintiff barred by law of limitation over historical equation and also hit under the provision of CNT Act, Bill Act, and specific law. Defendant has revealed para 2 of the written statement that the plaintiff is barred by limitation as provision para 4 and 5 of the suit is barred under by the CNT Act, Bill Act, and specific law, and also barred by the over historical equation. The additional GP has committed the plaintiff has got full knowledge of wrong entry on land from 9/7/75 and final publication of record of right has been published on 10/8/79. So the plaintiff should have filed the suit within 10/8/91. And so far, the provision of limitation for correction of wrong entry the record of right, the relief sought by the plaintiff are declaring the right title interest of plaintiff or suit land and settlement in the record of right finally published on 10/8/79 is wrong and erroneous. So the plaintiff should have filed the patent suit within 12 years from the date of publication of record. The defendant has relied upon the rulings reported in 2003 to JLJR 708, in which the Honorable Court has been held pleased to hold. So Nagpur Tenancy Act 1908, Section 87 and 258, read with Article 65 of Limitation Act 1960. It cannot be held that there is no clear limitation of filing suit for declaration that the entry made in the revenue record of right is wrong and declaration of title and recovery of possession. Maximum period limitation of filing suit for declaration of title and recovery of possession and for challenging the entry made in the survey record of right will be 12 years from the date of final publication of record of right. Firstly, instantly suit of filed 8 years after revisal survey, the record of right in respect of the suit body was finally published in the name of defendant. Suit clearly barred by limitation, lower appellate court committed direct error of law in holding the contract. On the other hand, plaintiff has previously claimed that mother of the plaintiff had purchased suit body from Lodra by virtue of registered sale in 1956. And since she along with her family started residing there by constructing house there without any interference or objection from any colony, and while plaintiff was in possession of suit property on 15/4/2025, one person claiming to be the staff of the forest department threatened the plaintiff to dispose from the suit property on the basis of wrong and erroneous entry in the record of I finally published on 10/8/79. It is further pleaded that the forced threatening given by the forest division staff cast cloud in the mind of the plaintiff. When the plaintiff first time came to know that suit property had been wrongly recorded in the name of one Bihar Sarkar, the counsel plaintiff has submitted the cause of action for the suit first time on 15/5/2005 when the plaintiff was threatened by the staff of forest department could know that the suit property had been wrongly finally published in the record of rights, and therefore plaintiff has filed a declaratory suit within the jurisdiction of the court and 2006, which is within time. So suit of the plaintiff is not barred by limitation. Learning Council for the plaintiff relied upon the judgment of Union of India versus West Coast Paper Mills Limited and reported in 2004 to JLJR 162 and submitted that the process case in rule to put limitation Act 1963, Article 58, beside this Article 130, the right to sue may accrue to a suitor in a given case at a different point of time. Whereas in terms of Article 58, the period of limitation will be reckoned from the date on which the cause of action arose first. In the latter, the period of limitation will be differently computed, depending upon the last day when the cause of action arose. In the present case, I find that plaintiff has pleaded the cause of action on from Punjab when the staff of forest bank threatened her to dispose her from the suit body on the basis of the wrong and erroneous entry in the record. Plaintiff has claimed that she knew first time on 15/4 while she was in continuous possession over the suit land since 1956 and suit was wrongly recorded in the name of one Africa and the record of right published on 10/8/17. The plea of the plaintiff does not inspire confidence for provisional verified, which is certified copy of the order party. Case number 2268/72. I find that mother plaintiff as party to the suit, which is related to civil rights, was in my view the plaintiff with full knowledge about the wrong entry in the record of right from very beginning, finally published.
What is the date? What is the document on the basis of which they are saying that wrong entry was made? Knowledge of wrong entry. What is the document? The publication was made in the year 1979. What is the clinching evidence on record, as recorded by the learned High Court, that she had knowledge? What is it? The order passed in the case number 70 to 73, and the final order was passed prior to 1979. Can that be a date of knowledge?
Because she did
Can you take it as a date of knowledge of the final publication of the record of right?
Because she did participate in the.
So what?
And that.
No.
That
Final publication of the record of right, that will depend when the state government would do it. They may take 10 years to finally publish it.
Maybe.
Because it is an ongoing process. But any event which is prior to the final publication of record of right, how can that event be taken as a knowledge of final publication of record of right?
But that is still prior to the final publication, in which she did participate.
You see, ऐसे नहीं समझ आ रहा. A person is admitted in the hospital, critical care unit, right? A person goes and sees that he is admitted, and after 10 days he dies. And then he says, I have no knowledge about the death of the person. Can you impute knowledge about the death of the person on the basis that he was found critically in the critical care unit in the hospital? ये भाषा समझ आ रही है आपको? When the only document which has been placed on record and which has been relied upon by the learned trial court is section 83 proceeding, which is prior to final publication of record of right.
Meaning that in survey proceeding, she did participate.
Yes, she did participate, but the knowledge of final publication of record of right would come only after it is finally published.
Yes.
Then, how can the limitation start on the basis of a document which is prior to final publication of the record?
Subject to your ladyship satisfaction. In a survey proceeding, she had participated earlier, and on that basis, when the proceeding initiated the stance of the state, why dismissed?
Yes.
Why dismissed? And she participated. The inevitable result of final publication.
But what is the date of final publication? Maybe it is rejected, the claim of the state was rejected, but final publication can take place even after 10 years, because the final publication is not dependent on one adjudication. It is dependent upon the numerous adjudication which the state is taking up with respect to objections regarding proposed the not final record of right.
Not final.
Correct. Section 83 proceedings is at two stages.
Two stages.
One is prior to final publication, and second is after final
83.
publication. Both the cases, 83 is there. And the learned court also records that this is one thing. The learned court also records that if the publication is conclusive proof. From where does it get it?
Publication is conclusive. Final publication is conclusive.
Yes, but the court records that is a conclusive proof of everything. You just see how the court has recorded. You just have a look at it. It's good that you have read the entire judgment.
Yes.
You see?
Just
a moment.
But what the court, the entire court has been to. That's my plaintiff has full knowledge about the wrong entry.
How the court is including this full knowledge about the final wrong entry in the final publication?
Because final publication, because in draft also there is.
Draft is nothing, you see. भाई एग्जाम दिए रिजल्ट आया 2 साल बाद समझ गए ना
हम ठीक है समझ रहे हैं
रिजल्ट का नॉलेज कैसे होगा
but in draft also as a right state of
you see the cause of action there is a draft which will translate into a final publication. The cause of action to challenge the final publication will come only when the final publication is done. उसके पहले तो नहीं हो सकता है. And when this final publication is done in the year 1979, where is the date of knowledge recorded in the improved journals? Not there.
But
They are
even
every.
record of right is itself not a document of title. That is another issue.
That is another issue.
But the claim of the plaintiff regarding plaintiff's title, because it's a substantial question of law, assuming it to be answered in favor of plaintiff, what will be effect? Whether plaintiff has succeeded in proving his title.
Yes, of course, on the basis of the same.
How Ladura has derived the title? That is silent. How Ladura hold
That is not the
chain of title is not established. How the learned trial from both the courts are held.
No, they have said that you just see. They have said that she acquired title on the basis of oral settlement by the original landlord.
That is recorded in the deed.
You see, once there is a registered, that is recorded in the deed. Once there is a registered document in connection with any property, and the person is also admittedly they are in possession of the property. There is no doubt on that. The person is also in possession of the property by virtue of a registered document.
But he is taking simultaneously that on the basis of adverse possession.
Maybe, so certainly that is separate. That is separate. We will deal with it. But the person is in possession of a property by virtue of a registered document, and their possession is not in dispute. You challenge that possession at appropriate stage, and your petition was rejected. Correct?
But his position has not been confirmed. That has been recorded. That finding is not there. But the regarding main point is that whether plaintiff has right title interest on the basis of sale deed and simultaneous taking plea of adverse possession. Both can.
Okay, let's take it. Let's take it that they cannot take it. They cannot take it simultaneously. The title is so clear. They don't need adverse possession to get a title over the property.
But they have taken it.
They have taken it. We'll deal with it.
The inconsistent plea cannot take it.
We will deal with it. Don't worry about it. They have cited a judgment. Have you distinguished that judgment?
I will also.
You come to the judgment.
I will also give one judgment. In a case of case versus Gendal 2010, that this suit is also for declaration of title and for permanent injunction. Whereas 7 and 8, if you already permit.
Yes.
Having gone through the impugned judgment and order passed by the High Court as well as the first appellate court, and even that of the learned trial, it appears that order plaintiff fled for declaration and claimed a title of ownership on the basis of sale deed dated 31/8/2021, and simultaneously the plaintiff also claimed the title by adverse possession. All the courts below have negated the claim of the plaintiff ownership on the basis of the registered sale deed dated 31/8/2021. Therefore, the only claim of the plaintiff on behalf of the plaintiff was of the plea of adverse possession. So far, the plea of adverse possession is concerned, the High Court has specifically framed substantial question of law reproduced hereinafter, and as such has held the same in favor of the appellant or the defendant one. The High Court has specifically observed and held that the plea of ownership based on the sale deed and plea of adverse possession both are contrary to each other, and the plaintiff cannot be permitted to take both the plea at the same time. Therefore, even as per the High Court, and claims plaintiff on the basis of adverse possession was not tenable. In that view of the matter, once the substantial question of law and adverse possession was held in favor of the appellant or the defendant one, and the title of ownership claim on the basis of sale deed dated 31/8/2021 was negated by all the courts. Thereafter, the alleged possession / alleged possession of the plaintiff could not have been protected by passing a decree of permanent injunction for the plaintiff. Under the circumstance, the High Court has materially erred in dismissing the bill with confirming the judgment and order passed by the first appellate court. In view of the above and reasons stated in plaintiff appeal 63, the appeal judgment and order passed by the High Court in case of and judgment and order passed by the first appellate court are hereby passed on safe side, and judgment and decree passed by the trial court are dismissing the hereby restored. And it is right law, it is copy that.
The learned counsel for the respondents has read the entire findings of the learned trial court on issue number 4 and 5. and also on issue number Roman 3. He has submitted that the plaintiff had claimed title over the property by virtue of registered sale deed number 3518 dated 8/8/1956, and ultimately the court found that the registered sale deed was hit by the provision of section 46 of Tenancy Act. This finding was recorded on the face of Exhibit 1, which revealed that the vendor of the mother of the plaintiff, Lodra Ho, belonged to scheduled tribe, and the mother of the plaintiff belongs to Christian community. The court has also recorded that in the sale deed there is no mention that due permission from the Deputy Commissioner was taken before transfer of the property. And these facts regarding taking due permission from the Deputy Commissioner to transfer the property has also not been stated by the plaintiff in the plaint or in the documentary or oral evidence. The learned counsel has also submitted that on account of the aforesaid defect in connection with the registered sale deed, the learned trial court has rightly held that the sale deed executed by Lodra Ho in favor of mother of the plaintiff becomes void ab initio, and title of the land cannot pass to the mother of the plaintiff through the sale. Finding it, the learned counsel submits that the fact as to the required permission, the point regarding violation of section 46 of Tenancy Act is a pure question of law, which can be raised irrespective of any pleading or proof to that effect. They submitted that it was for the plaintiff to prove her case, and she has failed to prove her title on the basis of the registered sale deed dated registered sale deed Exhibit 1. The learned counsel has further submitted that the court has recorded that there is a presumption in connection with the entries made in record of right, and the plaintiff has failed to bring any substantive material to rebut the legal presumption. This has been recorded after having held that the sale deed Exhibit 1 was null and void. The learned court thereafter held that the plaintiff was claiming title on the basis of registered sale deed and simultaneously claiming adverse possession without any foundation pleading, and the plea are inconsistent with each other, and for that he has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2022 bracket close 10 SEC 217 paragraph 7. the learned counsel has further submitted that the plea of the plaintiff claiming title and also adverse possession has been rightly rejected by the learned trial court, and the finding has been upheld by the learned first appeal. So far as the point regarding limitation is concerned, he has submitted that the plaintiff had full knowledge of the wrong entry on and from 9/7/1973, and the record of right was finally published on 10/8/1979, and the suit as per the suit should have been filed. Yes. 10/8/1979. The learned court has recorded that the plea of plaintiff that she had no knowledge did not inspire confidence on the basis of Exhibit 5, which is a certified copy of the order passed in the case number 2268 of 7273, in which the mother of the plaintiff was a party which related to the suit matter. And therefore, the court recorded that the plaintiff had full knowledge about the wrong entry in the record of right from very beginning, finally published in the year 1979. And therefore, the court rejected the plea that the entry was that she came to know for the first time about the wrong entry only on 15/4/2005. However, during the course of hearing, it transpired that Exhibit 5, the order was finally passed in Exhibit 5 on, what is the date?
10/9/1979. This is a survey of a chip.
No, Exhibit 5. That is, your claim was rejected. जो कला दिखा रहे हैं, 24/8/73 and
24/8/1973.
on 24/8/1973, which was certainly much prior to the final publication of the record of the thing.
The question of law. The question of law almost all has been dealt in my submission.
By referring to the substantial question of law, the learned counsel has submitted that the submissions which have been recorded as aforesaid covers all the substantial questions.
One thing, just regarding गवर्नमेंट का क्या होता है, इस पर अपेक्स कोर्ट ने क्या किया है, हम पढ़ देते हैं।
क्या चीज?
दिखाते हैं गवर्नमेंट का जो हिस्ट्री कहीं आ जाता है रिकॉर्डिंग उस पर है, लेकिन फैक्ट थोड़ा सा इसमें डिफरेंट है।
क्या चीज पढ़ रहे हैं?
एक जजमेंट
अब जजमेंट का कॉपी दीजिए, पढ़िए।
हम सिर्फ पारा 19 दिखा रहे हैं। फैक्ट में समझ पारा 19 से पारा 19 onwards. Suit for declaration of title against the government, though similar to suits for declaration of title against private individuals, differ significantly in some aspects. The first difference is in regard to the presumption available before the government. All lands which are not the property of any person or which are not related to the local authority belong to the government. All unoccupied lands are the property of the government, unless any person can establish his right or title to any such land. This presumption available to the government is not available to any person or individual. The second difference is in regard to period for which title and or possession had to be established by a person suing for declaration of title. Establishing title possession for a period exceeding 12 years may be adequate to establish title in a declaratory suit against individual. On the other hand, title possession for a period exceeding 30 years will have to be established to succeed in the suit for title against the government. This follows from Article 112 of the Limitation Act 1960, which prescribes a longer period of 30 years as limitation in regard to suits by the government as against the period for 12 years for suits by private individual. The reason is obvious. Government property are spread over the entire state, and it is not always possible for the government to protect or safeguard its property from encroachment. Many times, its own officers who are expected to protect its property and maintain a proper records, either due to negligence or collusion, create entries in record to help private parties to lay claim of ownership or possession against the government. Any loss of government property is ultimately the loss of the community. Court owe a duty to be vigilant to ensure that public property is not converted into private property by unscrupulous elements. Many civil suits deal with suits for regulation of title and injunction against the government in a casual manner, ignoring or overlooking the special feature relating to government property. Instances of such suit against the government being routinely decreed, either ex parte or for want of proper contest, merely acting upon the oral assertions of plaintiff or stray entries are common. Whether the government contests the suit or not, before a suit for regulation of title against the government is decreed, the plaintiff should establish either his title by possessing the title deed which satisfactorily trace title for a minimum period of 30 years prior to the date of the suit, except when title is claimed with reference to grant or transfer by the government or statutory development of it, or by establishing a first possession for a period of more than 20 years. In such suit, court cannot ignore the presumption that they will favor government, grant, declaratory, or rejective against the government by relying upon one of the principles underlying the pleadings in the plaintiff arguments which are not denied or traversed or deemed to have been accepted or admitted. A court should necessarily seek to answer the following question before it grants a decree declaring the title against the government: whether the plaintiff has produced the title deeds, placing the title for a period of more than 30 years, whether the plaintiff has established the first possession to the knowledge of the government or to the knowledge of the government for a period of more than 30 years, so as to convert his possession into title. Incidental to that question, the court should also find whether the plaintiff is equal to owner or holder of the equivalent of the property in the revenue records or municipal record for more than 30 years. What is the nature of possession claimed by the plaintiff? If he is authorized or unauthorized, policy, casual, criminal, or effective, clandestine, open, continuous, and style deemed or implied. This is the mere temporary use or occupation without any must to claim ownership or mere use or at sufferance is not sufficient to create any right that refers to the government. In order to oust or defeat the title to the government, the claimant has to establish a clear title which is clear or greater title to the government, or establish perfection of title by first person for a period of more than 30 years. To claim the first person condition, the claim must be clear, open, visible, hostile to the owner, and continue during the entire period necessary to create bar and law of limitation. Short, it should be continuity, publicity, and be a vague and doubtful and assertion that the claimant has in the first person will not be sufficient. When spent stray or sporadic entry for a year or for a few years will not be sufficient and should be ignored.
The learned counsel of the respondents has referred to the judgment passed by the Honorable Supreme Court put in bracket 2010 bracket 5 SSC 203, paragraph 19 and 20, to submit that the courts owe a duty to be vigilant to ensure that the public property is not converted into private property by unscrupulous elements, and has also submitted that it has been held as whether the government contests the suit or not before the suit for declaration of title against a government is decreed. The plaintiff should establish either his title by producing title deeds which satisfactorily trace title for minimum period of 30 years prior to the date of the suit, except where title is claimed with reference to a grant or transfer by the government or a statutory development authority, or by establishing adverse possession for a period more than 30 years. In such suit, court cannot ignore the presumption available in favor of the government, grant, declaratory or injunctive decree against the government by relying upon one of the principles underlying pleadings that the plaintiff averments which are not denied or traversed are deemed to have been accepted by the court. What is the impact of a CNT being declared null and void? Two questions I'll ask, and that is one. What is the impact of a CNT being declared null and void?
That doesn't confer title to the plaintiff.
It does not exist at all,
It doesn't exist at all.
right? There is a presumption in connection with the entries made in record of right. There is presumption.
Presumption of its correctness.
Yes, presumption of its correctness.
Not of the
right?
not of the title.
That's right. There are two entries in the record of right.
Ah,
One is your title,
yes.
and other is their possession since 1971.
But
So there is a presumption with regard to the correctness of the record of right. There is a presumption.
That is to be read as a whole, not one part.
That's what do you mean by as a
But the document is to be read as a whole.
Yes,
You want-
two parts.
Two
One
parts.
is title and other is possession.
Other-
They have been shown to be in illegal possession
In
since
illegal.
1971. Right? That there is a presumption in connection with this entry in record of right. And you cannot say that you are not aware because you contested it at one point of time. So you are very well aware that there is an entry in record of right that they are in illegal possession of the property.
Showing illegal possession.
Right? Right? Your objection was rejected. That attained finality, which ultimately resulted in final publication of record of right with your title and their possession. So there is a presumption that they are in possession since 1971. There is no evidence on record as to what you did after 1971. There is no evidence, no iota of evidence on record as to what you did from 1971 till the date of filing of the suit. Right? If they claim title on the basis of a document which has been declared null and void, it means they have no basis for title. So title goes completely adverse possession. So there is no question of any conflict.
Adverse possession, but their claim is not on the basis of their claim is that on the basis of sale did they have a continuity possession. Long possession.
So that has been declared null and void.
Long possession does not amount to adverse possession.
That's right. That document has been declared null and void.
Yes.
So therefore, any right, title, interest, possession on the basis of that document
But he has
does
to-
not exist at all. It has not been declared void. It has been declared null and void. It means it never existed.
But the plaintiff,
Let's take that 1956 statement never existed. Correct? Then under such circumstances, what existed is the entry in record of rights in connection with which there is a presumption of correctness.
but the plaintiff had to admit the title of someone, but plaintiff is not
No,
admitting.
Plaintiff has no option but to admit your title because of the entry in record of right. Because of the entry in record of right, your title stands admitted because there is a presumption. Correct?
But that possession does not amount to adverse possession. By some say.
That possession does not amount to adverse possession. What else would amount to adverse possession?
because that is encroacher. Because this judgment also
Encroacher is the adverse possession.
because the judgment also said that sometimes it so happens that is unexplained stray and sporadic entry for a year or few years due to lapses on the part of the lowest ranks of the authority. ऐसा होता है लिखा हुआ है.
देखिए इसमें collusion की कोई बात नहीं है because you have not
But
stated
that should be
anything
pleaded.
on
That should be pleaded.
clearance.
मैंने हमको plead हाँ.
कोई collusion की बात नहीं है. आपने contest किया हार गए. ठीक है? तो जब contest होता है तो proper decision making होता है कि इसको contest करना है. It is not something that GP एक petition file करते हैं. ऐसा तो नहीं होता ना. Instructions होता है, proper decision होता है. The deputy commissioner is also aware that such and such petition has been filed, and that was not taken to another level.
The matter which is record beyond that. They are the defendant did not reduce evidence. Leading is there. But my contention is that plaintiff had to prove his case And plaintiff has failed to prove. This is not my
He
essence
has
and
proved his case fully. He has proved his case on the basis of title deed, which has been wrongly declared to be null and void. You have not even stated in your entire written statement that this is null and void. Or declaration of null and void. Very good.
but the question of law has a
We'll see. We'll deal with it.
substantial question of law has also been
Yes,
otherwise.
Appealant, what do you have to say? ये conflicting plea का clear कर दिया.
हाँ,
I am not clear with the judgment you have cited and he has not distinguished it.
एकदम I must be clear. और इसमें बहुत सारा conflicting थोड़ा सा conflicting है.
पहले आप हमको अपना petition से claim से foundational pleading दिखाइए because that is also required.
ठीक.
The date on which it became adverse, that is also required. ये थोड़ा सा अपना
हम
claim
दिखा दे रहे हैं. हम बहुत simple रख रहे हैं. हम मतलब जितना भी cases which my learned friend is relying that it should have been uninterrupted, continuous, against, hostile towards the state, towards the person I am claiming, all these are established from the single document. Where it itself records in a survey that my possession is illegal. So, moment it is recorded in record of right that I am in illegal possession, and that too in a proceeding after draft publication, they objected to it, and I produced the sale deed of the year 1956. That has been taken note of. So, I am claiming on the basis of a registered deed, I am in possession. I have been recorded as illegal possession. So, even before 1971, I was absolutely claiming against the state. I was saying that I am the owner of the property. So, if this is what is adverse claim, adverse possession. Now, this is actually there are two, three types of adverse possession which is there. One is, let us assume that which the judgment, the trial court has recorded. One type of adverse possession is that. Your Lordship, I'll just go for it. This is reported in 1995, volume 6, SCC 309. Please, Your Lordship. I did not get a printout in it.
What do you want to point out? This
Yes.
judgment has been relied upon by the
Okay,
trial court.
what it says, what is this judgment is that I could not have, if the appellant intends to plead adverse possession against the state, he must disclaim his title and plead adverse possession to the knowledge of the state, and state has not taken any action within the prescribed period. So this is there in para 11 of that judgment. Para 11 of that. So what it said, what was the fact of that case? In that case, the fact was that the state settled a particular piece of land to a person who then transferred it to the appellant hearing, and then when the suit was filed, the appellant started claiming adverse possession against the state. So therefore the Honorable Court said that because you are coming in possession of the land over the property of the state on the basis of a grant made by the state itself, so once you claim adverse possession against the state, you must disclaim the type your coming into possession on the basis of that grant, and then only you can claim against the state. Now here this fact is not there. This is one. So if my learned friend has a particular property or a state has a property and I am claiming against the state, then I have to say that I am in claiming adverse to the state, the property belongs to the state, and I am claiming adverse to the state. So this is one. Second is, there are cases where there have been, your Lordship would recollect under C2 SAW and all, section 46, where there was a transfer 30-40 years back. All those transfers were made by scheduled tribe and in violation of the provisions of section 46. Let us say. Then also, the courts have held that after a number of years, this because there was adverse possession and the person to whom the property was transferred, because he was exercising or he was staying in the property as the owner of the property, because of, although the sale was illegal, but on the basis of that illegal sale, the person to whom the property was transferred, he was staying in the property as owner of the property. This is very important. So, the moment I start staying in a particular property, claiming myself to be the owner of the property, and the actual owner has the knowledge, he has the knowledge that on my property, he is the person who is claiming his right as the owner of the property, and he sleeps over his right. Here the state is there. Any person would be there, only 12 years is there, and state is 30 years. So, the person to whom the property belongs, he sleeps over his right to get the person ousted within a period of 12 years, to get appropriate proceeding initiate against such person who on my property he is claiming himself to be the owner, and he is in possession. This is very important. He is in possession, he is declaring himself to be the owner of the property, and then also I sleep over my right to get recovery of possession within a period of 12 years or 30 years, whatever may be.
No,
when
does the adverse possession ripen? Does it ripen upon expiry of 12 years possession?
Yes. It would only culminate, it would start from a particular date. This I'll be very clear. It has to start from a particular date, and 12 years, the moment 12 years expires.
Which is that crucial date when it starts?
In my case.
In your case?
71. Undisputably 71.
No.
When,
71 you are in illegal possession.
yes.
Will it start from 71 or it will start upon expiry of the period prescribed?
No, your Lordship may take up Article 65. Your Lordship.
The limitation. There's 65.
Article 65, it says that any suit based on title. So here 64 and 65 is there. 64 is when a suit is filed only on the basis of a prior possession. Their title is not required to be pleaded. So only prior possession has to be shown.
No, 65
So-
is for possession of immovable property.
Based on title. Based on title.
Yes.
So here is a case, here because there are two aspects of that. Here my plea is that this is adverse possession which is there in Article 65, and if the property belongs to the state, then the
We'll
state,
replace 30 in place of 20.
yes,
Right?
yes,
Now you tell us when the possession of the defendant becomes adverse to the
adverse.
So
So-
when does it become adverse? From the date of possession or upon expiry of 12 years from possession?
No, it says that when the period of 12 year or 30 year would start to commence, when it would start to run,
Yes.
that limitation
Yes.
30 year
It
when
will
it
start to run when the possession of the defendant becomes adverse to
adverse.
the When
So,
does it become
yes,
adverse?
in my case it would be, 1956 when I am starting.
Forget about
No,
1956.
I'm
When you are
taking alternative plea
no,
also.
please don't take it simultaneously. According to you, when does it become adverse?
It starts, the time begins to run. This is the
If you
column.
take the record of rights.
Yes, it starts to run from 1971 and it ends in 2001. Because the recording is that I am in illegal possession, the state objects to it by filing an objection to my illegal possession, and there I show my
You
deed.
see, it does not say when the party is in possession. It does not say from the date of possession. It says when the possession becomes adverse to the party.
Yes, adverse.
When does it become adverse?
It becomes adverse because my possession is illegal possession, not legal possession. The moment it records that my possession is illegal possession, that means it is being acknowledged that I
It
could
takes
not get
12 years to perfect the title by adverse possession.
Yes.
So it becomes adverse
Upon expiry, this is
upon expiry of
yes,
12
yes,
years.
yes. This date of 12 year, it starts to run from the date when my possession becomes adverse.
Yes,
And
that would become
that would be
adverse
19
upon expiry of 12 years.
Yes, that would be complete, and therefore, why this 12 years is there? Because the person whose property is there, who is claiming title, so he has the right to file a suit within the period of 12 years from 1971. In the, I am putting this in instant case, from 1971, 12 year or 30 year, the state or the actual title holder has a right to file a suit. Then it cannot be said to be barred by limitation. It would become barred by limitation the moment that period of 30 year expires. And then the adverse possession is
Now show me your pleadings.
yes.
In response, the Learned Counsel for the applicant has relied upon the judgment passed by the Honorable Supreme Court reported in 1995, bracket close 6 SSC 309, paragraph 11. You just give me your this. You show me your plate. Where is your plea of adverse possession?
Your Lordship, I'll read the entire or the.
No, you just read that paragraph.
Para 7 and 8. That thereafter plaintiff searched and inspected the record of right and the suit property in the office of record room and would know that the suit property is only recorded in the name of one Bihar Sarkar, and the same is also shown in the remarks column illegal possession of Masih Dhani Prithvi, wife of so since the year 1971, that the suit property is in actual physical possession of the plaintiff since long more than 48 years from the time since her mother 8/8/1956 without any interference from any corner whatsoever, and thereby the plaintiff has acquired indefeasing right, title and interest thereon by virtue of adverse possession well within the knowledge of all concerned whatsoever. The plaintiff has and is performing all her acts of possession of the suit property since more than 48 years without any hindrance from any corner, and thereby her possession and title over the suit property has been duly confirmed in the provision of law. That
The Learned Counsel for the applicant has referred to paragraph 8, paragraph 6 and 7 and 8
7.
of the plaint to submit that the foundational pleading for adverse possession has been laid down, and it has been asserted that the plaintiff has remained in possession of the property since 8/8/1956. He submits that even if the sale deed is taken as null and void, the possession since 8/8/1956 cannot be denied.
Yes. And your lordship, till date, no suit for recovery has been filed. No counterclaim was filed. I filed a suit in 2006, no counterclaim whatsoever.
He submits that the state never filed any counterclaim, nor any separate suit for recovery has been filed.
Yes, because I already filed a suit. They were aware about my claim. In 1973, they filed an objection. Instead of filing an objection because I was being recorded in illegal possession, they were required to file a recovery because settlement officer could not have granted.
Your witness has stated in cross-examination that the property vested in the state.
Vesting in the state, your lordship,
Everything vested in the state.
no. Vesting is one thing. Now, Rayati right never vests. Rayati right would remain with the Rayat would remain. Earlier he was the Rayat of the Jamindar. Now, after vesting, he would become the Rayat of the state. This is the only thing. Only what vested was the Jamindari right of the landlord. So, merely because one line I have
No
stated,
return of Jamindar etc. has been filed.
it is not. It is not there. So,
Even you do not, you have not filed it.
so and your lordship, it appears that
Could it be
subsequent
declared null and void without any pleading?
that question of law is not there. But your lordship, what happened that my
If that question of law is not there, then that finding has attained finality.
no, why you say? Because I could not have because
Because
that
section
was
46 is there. It has been held to be barred by the provision of Chotanagpur Tenancy Act. It has been held null and void because of violation of Chotanagpur Tenancy Act.
yes. So question number 1 would
Yes.
be connected to that.
Yes, certainly.
Question number 1.
Yes.
Because and question number 4 also, because my suit ultimately is being dismissed on the ground of barred by limitation, which is, as your lordship took note, that it is directly against the asset. So in 1979, when the final publication was made, I did not know, and my learned friend refers to, as your lordship pointed out, in 1973. So this final publication is not made in my record. If my order sheet would have culminated into a passing of a final publication, then the matter would have been.
The learned counsel has also submitted that the finding of the learned trial court that the sale deed of 1956 was void and initio is referable to substantial question of law number 1, as the sale deed has been held to be null and void on account of alleged violation of provision section 46 of Chotanagpur Tenancy Act, but no such foundational pleading was laid by the state in their written statement. That's all. That is all.
That is.
Done.
And your lordship, this time and again comes question of adverse possession. Now, if I am claiming a particular property on the basis of my title, then law does not prohibit me to take an alternative plea, as therefore I had relied on that judgment on the earlier day. So
It
law,
was a judgment 2010.
it was by Honorable Justice Ravindran. Yes, Ellen Aswatham.
इसको थोड़ा एक बार पढ़ना please. How does it make a difference?
हम बता
इसको थोड़ा fact पढ़ना.
हम फैक्ट में देखें. पैरा 3 से एक बार पढ़ लें
हाँ, पढ़.
थोड़ा सा, क्योंकि अल्टीमेटली वही है. In brief, the case of appellant plaintiff is as follows. The suit property was purchased by one Hanu Makka from the state government in the year 1940. She sold the said site to one Bellari Mulliswamy Pillai under the sale deed dated 23/9/1940, who in turn sold it to the appellant's father named Narayanappa under the sale deed dated so and so. The said Narayanappa was registered as owner of the said plot in the village records and was paying taxes therefore. Narayanappa suffered a stroke and after prolonged illness died on so and so, leaving behind all the properties to his sons, the plaintiff under his will dated so and so. The plaintiffs were unaware that their father owned the said plot as before at the time of death they were prosecuting their studies and were not conversant with the father's affair. Their father had taken some loan from Canara Bank as a security therefore and had mortgaged the said site and other property. The bank obtained a decree for sale of the mortgage property. The bank plaintiff became aware of the suit property and only after cleared loan due to the bank and brought back the various title deeds deposited with the bank on 9/1/1984. Thereafter, they took steps to trace the suit property and collect the necessary papers and found that the defendant who had no right or title was in possession of the said property by putting some temporary unauthorized structure or taking cattle. The appellant therefore filed the said suit. The respondent defendant resisted the suit by denying the title of the plaintiff and claiming title to the suit property in himself. According to him, the title belonged to one so and so, that after his death the said property devolved upon his wife Gauramma, that ever since 1962 he was tethering his cows in the said property with the consent of so and after the death of so and so continued as Gauramma's tenant and ultimately the said Gauramma sold the scheduled property to him under the registered sale deed dated so and so. The defendant also contended that he is in continuous undisturbed possession of the suit property for more than 30 years. He has perfected his title by adverse possession. To support his claim of possession, he relied on so and so. So, Your Lordship may kindly take note of the Gauramma, through Gauramma, the defendant was claiming.
Now the High Court also did not decide the case properly and ultimately the following questions arise for consideration.
Yes.
Number 9.
Whether the plaintiff have established their title to the property and entitled to possession, whether the defendant has proved his title to the scheduled property, whether the defendant has perfected his title by adverse possession, then therefore the suit is barred by limitation. Now, question number 3 is important. That Your Lordship would get from para 17 and 18. It starts from para 16, but 17 and 18. Or I'll read 16 also as
Please read.
The plaintiffs contended that the plea of adverse possession put forth by defendant should fail in view of inconsistent stand taken by the defendant. It is pointed out that the defendant had specifically contended that he was a tenant of the scheduled property from 1962 until he purchased the property on 18/11/1985. According to the plaintiff, this was a case of permissive possession and not adverse possession. It is submitted that the defendant, having put forth a case of permissive possession, cannot put forth a plea of adverse possession. It was submitted that even assuming that there was long and continuous possession for more than 12 years, that by itself would not constitute adverse possession. If it is or was either permissive possession or possession without animus possandi, according to them, the two pleas being mutually inconsistent, the latter plea would not even begin to operate unless the former was renounced. Reliance has been placed on the following observation of this court in so and so, while considering a case where the defendant raised a plea of permissive possession and adverse possession. As regard the plea, it is inconsistent with the second plea. Having come in possession under the sale agreement, he must disclaim his right thereunder and plead and prove assertion of his independent hostile adverse possession to the knowledge of the transferor or his successor in title, in interest, and that the latter has acquiesced to his illegal possession during the entire period of 12 years, that is up to completing the period of his title by prescription, so and so, not by violence, not by stealth, not by permission. Since the appellant's claim is founded on section 53A, it goes without saying that he admits by implication that he came into possession of the land lawfully under an agreement and continued to remain in possession till the suit, and thereby the plea of adverse possession is not available to the appellant. Now, here I'll pause. I'll just point out here. Here was a case where the person who was claiming adverse possession had come in possession on the basis of agreement from the same person.
That's
So now he could not have taken a plea adverse to that. If he was taking a plea adverse to that, after coming into possession, he was required to demonstrate that no, he had started
he had an
claiming.
independent title by way of
Absolutely, absolutely. His interest was again the owner, actually. That the legal position is no doubt well settled. To establish a claim of title by prescription, that is adverse possession for 12 years or more, the possession of the claimant must be physical, actual, exclusive, open, uninterrupted, notorious and hostile to the true owner for a period exceeding 12 years. Now here I'll pause. All these I'll show from our case that we have established. Now we were claiming on the basis of sale. Our possession was recorded illegal and all. It is also well settled that long and continuous possession by itself would not constitute adverse possession if it was either permissive possession or possession without animus possession. The plea based on title and adverse possession are mutually inconsistent, and the latter does not begin to operate until the former is renounced. Unless the person possessing the property has requisite animus to possess the property hostile to the title of the true owner, the period of prescription will not commence. We are, however, of the view that decision in Muhar Lal relied on by the plaintiff is inapplicable, as the defendant therein had pleaded that he was in possession, having obtained possession in part performance of the sale agreement. As the defendant therein admitted that he came into possession lawfully under an agreement of sale and continued to remain in such possession, there was no adverse possession. This case is different, as the defendant did not contend that he entered in possession under or through the plaintiff. His case was that he was in possession as a tenant under Gauramma from 1962, and he became the owner by purchasing the property from Gauramma in 1985. He alternatively contended that if Gauramma did not have the title and consequently his claim based on title was rejected, then having regard to the fact that he had been in possession by setting up title in Gauramma and latter in himself, his possession was hostile to the true owner, and if he was able to make out such hostile possession continued for more than 12 years, he could claim to have perfected his title by adverse possession. There is considerable force in the contention of the defendant, provided he is able to establish adverse possession for more than 12 years. When a person, here is the law, ratio. When a person is in possession, asserting to be the owner, even if he fails to establish his title, his possession would still be adverse to the true owner. Therefore, the two pleas put forth by the defendant in this case are not inconsistent pleas, but alternative pleas available on the same facts. Therefore, the contention of the plaintiff that the plea of adverse possession is not available to the defendant is rejected. So here, identical case is there. We are claiming that my vendor Ladura, who was the owner, he transferred me the property in 1956 by registered deed, and I have title on the property on the basis of the said registered deed. But if ultimately title is not established, then because I am claiming my title through Ladura who and the sale deed made by him, the state, which is absolutely a third party, I'm claiming my possession adverse to the claim of the state.
That's all. एक बात वो जो डॉक्यूमेंट है आपके लिए
हाँ।
प्रोड्यूस
ये जो
एग्जिबिट 5 come to the second last page.
ये थोड़ा आगे पीछे your lordship may kindly take the page number because in my page number yes
जैसे आपका है वैसे मेरे पास है।
your lordship may kindly take order dated 24/8/1973
24/8/73
yes
इसमें कौन सा ऑर्डर रिकॉर्ड करते हो आप?
yes first it mentions 8/8/1973 that it says that Java Swikriti, but it appears that no one was appearing on that date. It is clear from 8/8/1973, page 2 last.
That's right. That was
So
expired.
Java Swikriti, but पुनः संस्थापन के लिए आवेदन सुना, and then it refers to दावा अस्वीकृत, but then it also mentions the other portions of the same page, page 3. Your Lordship may see. प्रतिवादी के अनुपस्थिति के कारण दावा एक पक्षीय निर्धारित बदर स्वयं आदेश से खाता बनाया गया है। प्रमाण में सन 1956 का कहवाला प्रस्तुत किया गया था। गैर मजरूआ जमीन का बंदोबस्ती बिना स्वयं बंदोबस्ती के प्रमाण उल्लेख कहीं नहीं है, अतः वादी का दावा साबिक के आधार पर मान्य ठहरता है। Then again it mentioned दावा स्वीकृत, तीसरा नंबर स्वयं खाता से विलोपित कर अंकित करें तथा अवैध दखल मसीह धानी तिर्की सन 1956 लिखे। So here the settlement officer is also recording that from 1956 itself he is in illegal possession, although subsequent whatever may have been the record of it.
उसके बाद क्या है? 14/8 के बाद
Then the next page here,
next page.
उपस्थित केवाला संख्या 8/8/1956 द्वारा लादूरा हो से मसीह धानी तिर्की ने मानगो थाना 2 बीघा जमीन में खरीदा है। विक्रेता लादूरा का टाइटल अपील नंबर से स्वतः सिद्ध किया जा चुका है। प्रमाणित प्रतिलिपि प्रस्तुत सन 1964 में खेसरा 2 बना जो मेरी अनुपस्थिति के कारण के खाता में प्रविष्ट हुआ था। प्रतिवादी की अनुपस्थिति में दिनांक 8/73 को एक पक्षीय विचारण कर निर्णय दिया गया था, जिसके फलस्वरूप वादी का दावा स्वीकृत हो गया। प्रतिवादी के आवेदन पत्र दिनांक 16/8/73 के अनुसार पुनः संस्थापन किया गया। बदल का प्रमाण पर्याप्त रूप से स्पष्ट नहीं था। प्रतिवादी ने लादूरा हो से क्रय किया, जिसका स्वामित्व मानगो थाना 2 में ही टाइटल अपील नंबर 2 में मान्य ठहराया गया है। दावा अस्वीकृत, पूर्वादेश विलोप। So your lordship would note from this is the actual final order. Whatever may be the
Does it annul the order dated 14/8/73?
yes, it annuls the entirety. I had also while reading here itself now I was
Then what is the consequence of this?
consequent that the settlement officer he passes an order that the state's objection is rejected in entirety.
Okay.
Even I could not have been held to be in illegal possession
That's right.
because earlier order he is recalling. He clearly mentioned that it was because of it was ex parte order dated 8/8/1973 को एक पक्षीय निर्णय विचारण निर्णय दिया गया, and then he is recalling and then he is rejecting the claim of the state completely. So he is in two accounts. He is acknowledging that प्रतिवादी ने लादूरा से क्रय किया, जिसका स्वामित्व मांडू केस नंबर 100 में विगत 1944 में ही टाइटल अपील में मान्य ठहराया गया। He is taking note of that and then is rejecting the claim of the state.
So there was a judicial proceeding in connection with the said it.
Yes, yes, and that was not annulled.
in connection with, not in connection with CNT, because it is 1944. The CNT is 1956. The vendor, there was some dispute in connection with the right of the vendor.
Title of the vendor, which appears that it was his title was ultimately affirmed in favor of Laduraho, and then he transfers the property in 1954.
Exhibit 5 पर भी है, आपने कुछ बोला नहीं है, कुछ बोलना है आपको Exhibit 5 को? That is a substantial question of law in connection with the interpretation of
I
Exhibit
must
5.
concede one thing.
But he has confined that Exhibit 2, substantial question 3 and substantial question number 2.
Confined means when did he confine?
Well, last letter, while recording submission, that is
No.
suffice. उन्होंने कहा ही था.
Order dictate it's just a moment.
आज नहीं.
पिछले दिन ना वो upload हो चुका.
अच्छा.
That order has been uploaded. He has referred to Exhibit 5.
Exhibit 5 referred, but substantial question of law, he has submitted that the one would suffice the purpose.
नहीं
ऐसा कोई recording नहीं है.
इसमें 2 और 3 को बोल रहे थे आप?
आप तो
Two,
आए
three,
थे
एक साथ
बाद में.
होगा.
आप तो कब आए थे? जब इनका argument conclude हो गया था.
हाँ, conclude.
हाँ,
2,
इसलिए
3
ऐसा
एक साथ
करते
होगा,
हैं.
ये
याद
बोले.
रहता है सब.
हाँ नहीं ठीक, हम लेट आए थे.
आप तो लेट से थे. आप तो
हाँ.
जब इनका conclude हो गया था, जब आपका भी conclude हो रहा था, तब आप आए थे.
हाँ.
You were not there in the court. And that is
But
not
the
the
question-
submission.
but the question
You have seen Exhibit 5.
Exhibit 5.
बहुत अच्छी बात है. That is a substantial question of law. Neither you have seen it nor any submissions have been advanced. चलिए हो.
हमने दिया है जो स्टेटमेंट हमने दे दिया है और हम रिटन नोट्स ऑफ आर्गुमेंट्स
नहीं हमको
By
नहीं.
Monday.
आप कोई नहीं.
बाय मंडे.
नहीं. Whatever you have submitted, that is full and final. I have recorded every submission of yours. अब इतना submission record करने के बाद आप कोई.
हाँ ठीक है, my one submission will be recorded.
Yes.
Your ladyship posed to query from which date the possession has become adverse. He has not answered it. And there is no pleading, foundational pleading, specific pleading taking into consideration neck
This is not correct. He has answered it by saying that it became adverse from 1971. How do you say? Even as per the record of rights.
He has referred the contention of the
That I have recorded. इसके लिए दोबारा recording का जरूरत
a long possession even does not amount to adverse possession. Specific pleading is not there. My submission.
My last submission was there.
है.
Only last. Now, Your Lordship, despite this order passed by the settlement officer, there is a records were published in 1975, 9 where I was recorded to be in illegal possession, but it is only a presumption.
That's right.
Now, therefore,
We are aware
it is not
only a
conclusive.
presumption.
So,
It is not conclusive.
yes, so
इसके लिए
therefore,
submission का जरूरत.
once he passed an order by settlement officer, he passes an order, then the record of right ought to have been clear that where my title could not or my possession could not have been recorded as
The learned
illegal.
counsel for the respondent has also submitted that once the settlement officer has rejected the objection of the state with regard to the possession of the plaintiff, then under such circumstances the order ought to have translated in the final publication of the
Yes,
order.
yes. And my possession
Showing the possession since 1956.
and my possession could not have been recorded as illegal.
And the challenge of the state was that the possession of the plaintiff was illegal, and since their objection was rejected, therefore the possession of the plaintiff cannot be said to be illegal.
Yes.
उनका तो पूरा ही objection reject हो गया ना, तो जो था वही रह
हाँ,
गया.
वही
तो ये सही नहीं है ना आपका submission.
ठीक है,
Correct.
ठीक.
Post on 31st October. Arguments concluded. Order is judgment is reserved. Post on 31st October for judgment or any other day as may be notified by this court, whichever is earlier. एक तो डेट डाल देते हैं.
हाँ,
अगर
हाँ.
बीच में नोटिफाई हो गया तो you will.
ठीक है.
अदरवाइज क्या होता है ना कि पूरा कैलेंडर डेट रहना चाहिए, हम जुडिशियल ऑर्डर से कैलेंडर बनाएंगे. That's it. कम से कम कुछ नहीं होगा तो उस दिन तो आ जाएगा ना.
Now it is better that your lordship is only taking a few hearing matters, otherwise बहुत ज़्यादा उनमें से
जी हमने जानबूझ के उसको थोड़ा कम लिस्ट कराया है,
हाँ.
लेकिन everybody is aware that these matters are now coming up. It is expected that the councils will intimate their litigants. अब सेकेंड अपील सुनने में तो टाइम लगेगा ही ना.
नहीं
It will
ठीक,
take its own time.
at least they are being taken up.
कल ये इसका जब इसी का रिकॉर्ड या किसी और केस का एक रिकॉर्ड हम खोलने के बाद I sneezed for half an hour continuously. फिर उसको चीख भर के बात करते.
For finalists for item 3, second appeal 73 of 1997.
Yes, appellant. क्या बोलना है बोलिए.
Appellant is the plaintiff before the married court who is situated at title suit for the creation of right and title and interest over the property is Schedule A property loss. The plaintiff purchased.
Respondent, where is the respondent? They have been absent. Mr. A.K. Sani is not there.
Plaintiff purchased the suit property loss.
सूट कब का है?
Suit 88.
88.
Title suit number 42 of
82. Title suit number 81 of 82 and 42 of 88. It is originally of 82.
This title suit number 81 of 90, 91 and 42 by 82.
और body number हुआ हुआ है.
Yes. This plaintiff instituted title suit lawsuit for confirmation of his right at an interest lawsuit for Schedule A land lawsuit, which is he purchased the suit property lawsuit through registered sale deed from the original recorded tenant lawsuit.
Sale deed.
Sale deed lawsuit.
Sale deed dated.
Sale deed dated. Sale deed is exhibit 3 lawsuit. Sorry, exhibit 1 lawsuit.
Dated.
Exhibit 1 dated 6/1/87 for 1.66 triple land.
Yes.
Thereafter, petitioner filed an application for mutation lawsuit. Mutation case number 47R27
Sale deed dated 6/1/87.
6187. Exhibit 1. Minority already heard this matter on last. So note be clear.
जो जुडिशियल ऑर्डर में ट्रांसलेट नहीं होता उतना याद नहीं. तो जुडिशियल ऑर्डर तो ड्रॉ नहीं किए.
Yes, exhibit 1 is the sale deed lawsuit.
Then
Thereafter, plaintiff filed commutation of the land lawsuit. It was what lawsuit? Mutation case number 47R27/87/8788.
47R27/8788.
87/88. Yes, sir.
Okay.
Circle officer, while ordered 23/8/88 lawsuit, partly ordered commutation for the land of 0.90 half decimal. 90 decimal का भी mutation.
0.90
0.90 half decimal.
and a half decimal.
Yes, sir.
Why partly it was rejected?
Yes, partly.
Why was it partly rejected?
Yes, that is exhibit 6 lawsuit.
Exhibit 6.
Yes. against the partly of the invocation order lawsuit. The plaintiff filed the title suit lawsuit before the London Court given lawsuit. The suit was dismissed lawsuit. Against thereafter we filed appeal lawsuit. Appeal also dismissed lawsuit.
When you are claiming on the basis of registered sale deed,
Yes, ma'am.
why the mutation was not allowed fully?
Yes, can we see Annexure 6 lawsuit? Exhibit 6 lawsuit.
Because it exhibits. आपके पास exhibit 6 की copy है?
Yes, exhibit 6.
Do you have a copy?
Yes, certified copy.
उसको थोड़ा बोलिए ना, जो ऊपर में मैट्रिक्स रहते हैं उसमें exhibit black करें. Yes, please.
इसमें अगर हमने रिवर्ट द exhibit 6 28/3/88 अभिलेख उपस्थित हुआ आम इश्तहार किया गया ग्राम जेडा के पतरू घासी व दसरू घासी ने आपत्ति पेश किया. दे आर डिफरेंट नंबर 1 to 3 लॉक्स. प्रश्नगत भूमि ग्राम जेडा के खाता नंबर 39 गत सर्वे के समय मगलू घासी वंद नोवा घासी व सोना घासी व खसरू घासी के नाम दर्ज है. सर्वे खतियान के अनुसार उक्त खतियान के दो हिस्सेदार मगलू घासी एवं सोमा घासी है. श्री मगलू घासी के कोई पुत्र नहीं है, मात्र लड़की है एवं सोमा घासू के दो लड़का कष्टू घासू व महरन घासी है जिन्होंने जमीन की बिक्री की है. मगलू घासी के 3 लड़की में से नीरो घासी के घर पर ही शादी करके मगलू घासी अपना सेवा रहने के लिए रखा था, जिसकी मृत्यु के करीब 6 वर्ष पूर्व हो गई है. जैसा कि प्रतिवेदन प्राप्त से स्पष्ट होता है, उन्हीं के लड़के पतरू घासी, लसरू घासी व खसरू घासी आपत्ति करता है जो मगलू घासी के उत्तराधिकारी है. मगलू घासी के
Partition should decide कर दिया क्या इसमें?
इसमें पार्टीशन डिसाइड कर दी.
What is the substantial question of?
Yes, sir. This validated 5598. Heard the learned person for the appellants. This appeal has been filed
No,
against.
you just read the substantial.
Yes, substantial law. Whether in case of discrepancy between the entries in CS and RS record of right, the entry in RS of record will prevail.
ये तो settled है.
Settled law. RS record of right में हम इसे क्लेम कर रहे हैं. Second, whether the finding of the court below that the plaintiff have not acquired any title to the suit property or basis of misconstruction of title deed exhibit 1 and 3 as well as exhibit 5.
6 के पहले तो कुछ नहीं। Exhibit 5 क्या है?
हाँ, exhibit 5 है record of right. एक थोड़ा सा प्रैक्टिस हो गया सूट के साथ। जो लैंड है आरएस खाता नंबर इसको आरएस खाता नंबर 39 total area is 9.78 acre village Jarda PS Dumri district Gumla
Village Jarda.
village Jarda
PS
Dumri Gumla district Gumla recorded in the regional survey of record of right in the name of Magnu Ghasi and Magnu 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 Ghasi and Soma Ghasi. Yes, Magnu Ghasi had 3 daughters. Nero Ghasi, Biro Ghasi, and third died issueless. Name is not given.
Biro,
There. Nero Ghasi,
Biro,
and third one name is not there. She died issueless after her marriage.
issues.
Now Nero Ghasi had 3 sons. Khariya Ghasi.
Hariya,
Oh, sorry. Khariya Ghasi was the husband. Patru Ghasi.
Atru,
Patru Ghasi.
Patru.
Who is defendant number 1.
Yes.
And second son is Khasru Ghasi. Khasi. Khasru Ghasi. Who is defendant number 2. And third son is Lasru Ghasi. Is defendant number 3. And from Biro Ghasi, 3 sons are there. Rangila Ghasi, who is defendant number 4. Ponda Ghasi, defendant number 5. And defendant number 6 is Kiru Ghasi.
D6.
Yes, sir. As per total 9.78 acre
And
land.
who are the plaintiffs?
Plaintiffs are the purchaser.
Purchaser
Yes,
from?
from Soma. The next revision of record of right as the name is recorded in the name of Magnu Ghasi and Soma Ghasi. And Soma Ghasi's sons continue to record. Soma Ghasi had 2 sons. Kastu Ghasi, KASTU, and Maharang Ghasi, who is defendant number 7 and 8. Kastu Ghasi is defendant number 7 and Maharang Ghasi is defendant number 8. Who instituted a sale deed in favor of the plaintiff's lawsuit.
Both of them.
Both of them. Right, sale deed number 126 dated 16/187 for 1.66 acre land.
Dated 16/187
16/187 sale deed number 126
for
1.6 1 acre 66 decimal.
In RS record, the total area was
Total area was
9.78.
9.78.
okay.
So the दोनों की 4.
Out of that, they sold 1.66.
1.6. So 4.89 both are equally entitled also for 4.89 acre. Magnu Ghasi took 4.89 acre, Soma Ghasi 4.89 acre. So out of 4.89 acre lots, Soma Ghasi sons lots executed sale deed for 1.66 acre land.
Because the learned counsel for the appellant has submitted that the plaintiffs were claiming property on the basis of sale deed dated 6/1987 registered sale deed for 1.66 acres, which was executed in favor of the plaintiffs by 2 sons of Soma Ghasi, namely Kastu Ghasi and Maharang Ghasi. Kastu Ghasi and Maharaj Ghasi were pro forma defendants.
No, defendant 7 and 8.
Defendant number 7 and 8. They also did not support you.
They supported the
Okay.
they
Pro
filed
forma
also-
defendants बोलेंगे ना.
Defendant में गलती हुआ,
Defendant 7 and 8
Okay.
supported
Defendant number 7 and 8. He submits that the defendant number 7 and 8 had supported the case of the plaintiff. Right? By giving the details of property, he submits that after the purchase, the plaintiffs had applied for mutation,
mediation.
which was numbered as 47 with bracket R 27/87-88, and the mutation was partly allowed only to the extent of 0.90 and a half decimal by the order dated 23/6/88 with bracket exhibit 6. He submits that an appeal was also filed, but the same was dismissed, and ultimately the suit was filed.
That is the mutation of we have not no one prepared.
Acha, okay. The order of mutation became final, and ultimately the suit was filed.
Suit.
Seeking declaration of title.
Right.
The learned counsel submits that as per RS record of rights, Khata number 39 had total area of 9.78 acres, which stood recorded in the name of Maglu Ghasi and Soma Ghasi. The property was of village Jarda, PS Dubri, district Gumla. So far as Maglu Ghasi is concerned, he had only 3 daughters, Niro, Biro and one more daughter, who died issueless. Niro had 3 sons, Patru, Khatru, Khasru and Lasru, who were defendant number 1, 2 and 3 in the suit, and Biro had 3 sons, namely Rangila, Ponda and Kiro, who were defendant number 4, 5 and 6. He submits that the property was purchased from the legal heirs and successors of Soma Ghasi, who was shown in the record of rights along with Magnu Ghasi. The descendants of Magnu Ghasi were the contesting defendants. Correct?
Yes, sir.
Right.
And so far defendant number 4 to 6 loss, judgment was passed ex parte loss. 4 to 6.
Mr. Relevance.
Not very relevant. The state also not filed any
Not relevant.
ex parte. Yes.
Not relevant.
Yes, sir. Now, plaintiffs are in possession loss for the suit land. After purchasing the suit land, we have explained in paragraph 10 of my plaint loss.
Not
No.
relevant.
Yes. The relevant point is exhibit 3 loss. Exhibit 3 is the same date loss. The exhibit 3 is one Ranglal Ghasi, who is the son of Kastu Ghasi. Defendant number 7 sons Ranglal Ghasi, who sold the land that is exhibit 3 in favor of Lasru Ghasi, who is defendant number 3 So in the year 8186, defendant number 3 acknowledged the son of Kastu Ghasi, Ranglal Ghasi as owner loss. They also purchased the suit property on
Just a moment. 8186.
Yes,
is
exhibit 3
executed by exhibit 3 is
Exhibit
executed
3.
by
Ranglal Ghasi.
defendant number बताइए.
No, he is son of Kastu Ghasi.
Defendant number 4.
7 sons.
Defendant number 4 too.
No, defendant number 7 sons is Ranglal Ghasi.
Defendant number 7.
Kastu Ghasi son is Ranglal Ghasi.
Defendant number 7.
Yes, sir.
Son of defendant number 7.
Son of defendant number 7. Yes, sir.
What is his name? Rangila.
Ranglal Ghasi.
Okay. He sold it to
Who sold to defendant number 3, Lasru Ghasi.
the learned counsel submits that the son of defendant number 7, namely Ramlal Ghasi, has transferred a portion of the property by registered CNT dated 8/1/86 within bracket exhibit 3 to the defendant number 3.
So defendant number 3 acknowledged the stance of the plaintiff law.
Therefore, the defendant number 3 had duly acknowledged that
The ownership of
duly acknowledged the ownership of the property so far as a descendant of Soma Ghasi is
Soma.
concerned.
yes. The case of the defendant is Dorsey. Although they have not pleaded in the written statement Dorsey, the revisional survey record of right, which is RS Khata number 39 is Dorsey, which was named as CS record of right as CS record of right 37 Dorsey. In the name solely in the name of Magnu Ghasi. This is the case of, although they have not pleaded
In CS record,
in CS record of right,
it was
Which is-
only in the entire property was in the name of Magnu Ghasi.
in the entire property in the Magnu. This is the case law, although they have not pleaded also.
Okay.
That is exhibit D and D by 1. They have filed law. They have got exhibited also. Exhibit D and D by 1 also.
Magnu Ghasi exhibit
D and D by 1.
D and D by 1.
It is recorded as
Only in the
CS
name of Magnu Ghasi.
only solely on the name of Magnu Ghasi.
That's
But they are claiming law. Although they have not in the written statement, they have not pleaded anything also.
no foundation pleading.
No foundation plea also. The court suo motu only on the basis of exhibited document law. So D by D1 law came to a finding also. So the finding was perverse law.
The
That I will also show law. See, the exhibit D and D by 1 is there is discrepancy law. That is why the exhibit 5 and exhibit 5, which is the RS record of right, will prevail law. That I show law.
The learned counsel has submitted that there was no foundation pleading on the part of the defendant with regard to entry in CS record of right. However, they exhibited the CS record of right by exhibit D and D by 1, in which the property was shown only in the name of Magnu Ghasi.
Yes.
The learned counsel submits that there was discrepancy in exhibit D and D by 1, which ultimately got resolved when the RS record of right was published. And in RS record of right, the property was shown in the name of Magnu Ghasi and also
Soma Ghasi.
Soma Ghasi. The learned counsel submits that the law is well settled, that in case of discrepancy between entries in CS record of right and RS record of right, the entry in the RS record of right will prevail. For this, he has relied upon the judgment passed by this court,
By this only court. So,
by this court, Supreme Court का भी judgment है.
Supreme Court judgment. उसमें like paragraph 48 and 49.
Or what?
Passed by this one in second appeal number 2 and 19 of 22. I have already supplied on last one.
219.
200.
बताइए कहाँ?
Paragraph 48 and 49 also. Page 29.
For this, he has relied upon the judgment passed by the Honorable Supreme Court, reported in AIR 1963 SC 361, and also the judgment passed by full bench of Honorable Patna High Court, reported in 1987 PAGR 354. He submits that these two judgments have been considered by this court in second appeal number 219 of 2022. That's referred to है कोई ऐसा कोई finding नहीं है लेकिन खाली referred to. नहीं, he submits that he has also relied upon the judgment passed by this court, reported in 2003 within bracket 2 JLDR 708, where one of the substantial question of law was, inverted comma, I, what will be the effect in law of the two different entries made in two different survey settlement of record of rights under section 84 within bracket 3 of the CNT Act question. He submits that the same question of law was decided by holding that the subsequent record of rights would prevail over the previous one. He has also submitted that it is not in dispute that RS record of right is subsequent to CS record of rights.
Yes, although I would also observe this judgment lordship 2003 by 2032 judges 708 lordship. I only want to cite one paragraph number 9 lordship. 2003 volume 2 judges lordship.
Nothing?
Page 708 lordship. Para 9.
ये तो पैरा 49 में लिखा ही है,
लिखा हुआ para 9 plus
गलत लिखा है क्या इसमें पैरा 49?
नहीं para 9
The learned counsel has also placed the paragraph 9 of the judgment reported in 2003 within bracket 2 bracket close JLDR 708, which is quoted as a fine.
Now kindly see exhibit D lordship, which they are relying lordship. D and D by 1 lordship. The Khatyan of CS record of right lordship.
What is the discrepancy?
Yes,
Is there any finding recorded with regard to the discrepancy in D by D?
Learned trial court not recognize this document also. Kindly see this relates to Mauja Barwe and the suit land is Mauja Jarda also. And what they are getting this document also from लगान पाने वाले का नाम दिखाया गया है यहाँ पे शेख बहादुर अली को लैंडलॉर्ड यहाँ पे शो किया गया है एंड एग्जिबिट A and B वो भी दिखा देते हैं एग्जिबिट A they filed exhibit A lordship जमींदारी रसीद lordship no जमींदारी return no हुक्मनामा they have not filed lordship and they are claiming the exhibit A lordship जमींदारी रसीद with relate to महाराजा प्रताप इसमें exhibit A जो फाइल किया जितना सीरीज है वो महाराणा प्रताप से ये क्लेम कर रहे हैं कि लैंडलॉर्ड महाराणा प्रताप से एग्जिबिट बी रजिस्टर्ड सेट इसमें रेट रेसिट 2 लगा है DW7 lordship admitted there is a cutting in the red receipt lordship so there is also forged and fabricated document was filed
इतना कहानी हम आपको ये सब्सटेंशियल क्वेश्चन ऑफ लॉ में
हाँ वही देखा जो डिस्क्रिपेंसी क्या है वही हम दिखाना चाहते हैं खतियान
exhibit D is with respect to which property? कहाँ का property?
ये प्रॉपर्टी है ये शो कर रहे हैं मौजा बरवे लैंडलॉर्ड का नाम दिखा रहे हैं शेख बहादुर अली जो जमींदारी रसीद उनको मिल रहा है
आप कौन से सब्सटेंशियल क्वेश्चन ऑफ लॉ में
हम फर्स्ट दिखा रहे हैं जो डिस्क्रिपेंसी उसी को प्रूफ कर रहे हैं बी और जो सूट लैंड इज डिफरेंट लॉर्डशिप एग्जिबिट ए से जो क्लेम कर जो उनको जमींदारी रसीद मिला है वो महाराणा प्रताप सहदेव के फैमिली के थ्रू मिला है और जो खतियान निकला है वो नाम निकला है शेख बहादुर अली के नाम से now kindly come to exhibit my exhibit lordship exhibit
और exhibit D by 1
D by 1 में भी वही है दिखला रहे हैं कि बरवे मौजा बरवे के लिए है और लगान पाने वाले का नाम शेख बहादुर अली
कौन सा एंट्री नहीं पता चला।
एग्जिबिट डी देख रहे हैं।
जर्दा भी तो है साथ में।
नहीं मौजा देखा जाए बरवे
नहीं जर्दा भी तो है।
है कोरस्पोंड है
नहीं जर्दा नंबर 76 लिखा हुआ बरवे चैनपुर है शेख बहादुर अली के नाम से।
कोरस्पोंडिंग टू आरएस खाता नंबर 37 that has been found
नहीं वो हम दिखा रहे हैं। देख लीजिए लगान पाने वाले का नाम शेख बहादुर अली।
तो इसमें तो बहुत सारे एंट्रीज हैं, ऐसे कैसे हम इसको देखते हैं।
लैंडलॉर्ड का नाम हम शेख बहादुर अली के नाम से होता है।
कहाँ से हम देखें सीट बाहर
ओरिजिनल
मार्क करते हैं, पेंसिल से मार्क कर लीजिए। चैनपुर बरवे जर्दा ये महाराणा
प्रताप
जर्दा
सहदेव
चैनपुर
आरएस रिकॉर्ड ऑफ राइट जो बना है एग्जिबिट 5 वो महाराणा प्रताप सहदेव के नाम से बना। उसी के बेसिस पे जमींदारी रसीद भी अपना एग्जिबिट ए फाइल की एग्जिबिट ए फाइल की।
ये एग्जिबिट
डी बाई 1
और एग्जिबिट 5 तीनों आपके पास है।
हां तीनों
आप उनको एक फोटोकॉपी
इसके
कीजिए। आज
कॉपी
टाइम
करवा
खत्म हो
दें।
गया, कल सुनिए, कल कंटिन्यूटी में सुनिए, अब इतना नहीं सुनिए, सुबह 10:30 बजे। The learned counsel for the appellant has submitted that there was serious discrepancy. Has submitted that exhibit D and D by 1 did not relate to
एग्जिबिट 5
the property involved in the present case. And was relating to Moza Barwe, shown in the name of the landlord Bahadur Ali,
बहादुर
and exhibits A series are the entry issued by Maharana Pratap Singh.
महाराणा प्रताप सहदेव। यस
ये तो आपके जो है ना सब साइंटिफिक लॉ के बाहर जा रहे हैं।
एग्जिबिट 5 को भी देखा जाता है लास्ट जो आरएस रिकॉर्ड ऑफ राइट है ये महाराणा प्रताप सहदेव के नाम से ही
So far as the RS record of right is concerned, the same stands in the name of shows the landlord as Maharana Pratap.
yes sir land is also mentioned as Jada also
And the property has also been shown as
with Moja Jada
in Moza Jarda village. ये तो Moza Jarda district,
थाना चैनपुर डिस्ट्रिक्ट
PS Jaipur
PS
and
डिस्ट्रिक्ट गुंडा।
district. The argument has remained inconclusive. Post this case for further hearing tomorrow. Sir, आ जाएंगे प्लीज 10:30 बजे। इसका एक कॉपी देंगे आप?
यस हम आपको
हाँ, एक फोटोकॉपी हमको ये ना इससे निकालना और इससे पढ़ना थोड़ा मुश्किल होता जाएगा। आपके पास है सर?
नहीं है
उनको भी दीजिए। Get it photocopied and give it to him also.
यस इसको कंटेस्ट ये पास होना भी चाहिए फाइल भी किए एग्जीक्यूटिव फिर हम दे देंगे
फिर भी हम वहाँ से नोट कर लेंगे कोई दिक्कत
दे देंगे
नहीं ऐसा कर।
नहीं हम दे देंगे
आप दे दीजिए, नहीं तो आपका हियरिंग जो है 1 साल बाद कर
नहीं,
देंगे,
नहीं,
तब तक 2-4 लोग और मर जाएंगे।
आज